And be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
We're back. Hold on while I just do one more thing. Okay, hi. Hello, my friends. And we're back again for the second time today. Today is Thursday, April 9th, 2026. How is everybody today? How's everyone? There is a civil hearing on Karen Read at 4 p.m. I don't know if we're going to be able to stream it yet. Because although I have the Zoom information, they're very strict about restreaming. And so I know that there's one other like YouTuber who is streaming it. I'm not going to restream someone else's stream, but Court TV is reporting on it and Boston 10 is reporting on it. And if one of them streams it, I can restream it. Otherwise, what I'm going to have to do is I'm going to mute myself. I'm going to listen to the Zoom and I'm going to report back to you on what's happening. Because the thing is that I'm not going to be stricken for streaming something I'm not supposed to be streaming. And I cannot have anybody who's actually on the Zoom listening to me because some people don't know how to mute. And so then everyone hears me on the Zoom and they think that it's me who doesn't know how to mute, but it's really not me. Law and Crime is screaming it. Law and Crime is screaming it. All right. Woohoo. K Lady K, you win today's prize, which is a shout out from me for now. Hold on. Let me see if I can find it. Is it on the Law and Crime Trials or is it on regular Law and Crime? You know, now that Court TV and Law and Crime have become one because the Law and Crime bought Court TV, they have two different channels and everything is going to like streaming. Like they're not, do they have any live programming anymore? Or is it just, they have live programming or I mean like shows? Like does Vinnie Politan still have a show? Hold on. Well, I don't see it on Law and Crime's YouTube channel. It needs to be on YouTube for me to stream it. Hold please. Unless it's on their Trials channel. I know they're streaming, but I don't know. They've changed everything about everything about everything. And I don't know if they have the programming anymore that they used to. Does Vinnie Politan still have like his TV show, his shows like Closing Arguments and stuff? Hold on. But regardless, even if we can't stream the hearing, we will be able to stream. I have a new motion for you about Karen Read's team fighting with the town of Canton to get Sean Goode's records. David Yannetti has a new case that's very exciting to talk about. I mean, Law and Crime where, K Lady K? I just can't find it. If somebody wants to email me the link, it's fanbase at endlittleLaw.com, but I don't see Law and Crime streaming it unless it's on their TV. So unless you see it somewhere else. Boston 10 was reporting on the case, as far as I can tell. Sometimes they put it up, though, at the very, like, super last minute. I have the Zoom information, but I can't restream the Zoom. That's the issue. Because they're very strict, unless they say that I can, in which case I will. Sometimes they have like a blanket warning, and so I can't. But if I can, I will. Law and Crime has 3 different channels now on YouTube. What? All right, well, I've got there's Law and Crime Trials, right? Then there's Law and Crime Network. And then what's the other one? Law and Crime Network, Law and Crime Trials. What's the third one? I'm not aware of that. Usually they're okay with restreaming, but for some reason, this weird civil court, Judge Gilday in Plymouth County, doesn't allow it. But I will ask you very kindly. Oh, the body cam one? Okay, well, the body cam one's not going to be streaming this hearing. That's for sure. We know that. For some reason, Judge Gilday does not allow it. Court TV sometimes puts it up last minute. Let's see. Also, there was a hearing today in Fraser Bohm, and Court TV doesn't have it up. And Alan Jackson was not there. Somebody else was there for him, right? Looks like Court TV is showing it live on YouTube. Because I don't see it. I'm on their YouTube channel and I don't see it. Unless they have more. Unless, hold on. Unless you mean on their website. I can check. But then we got it. I mean, if we can, we will. But we also have to suffer through their commercials. Oh, please. They've got an article about it, but I don't see that they're streaming it. I don't know. Where do you see that, Rachel? All right. It was a month ago. It said live, but it was a month ago. That doesn't help. All right. Well, if you are in the Zoom because you have the information, I need you all to mute yourselves right now. Right now. And sometimes it'll pop up at the last moment. And so if I am muted and I'm not speaking, but I'm listening to the hearing and people come in and say, why is she muted? Why is she not speaking? You tell them. You tell them. Because of what has happened before, how people don't know how to mute in the Zoom. I can't talk while I'm listening to the Zoom because what had happened is everyone hears my voice and they think it's me because they don't, they could be listening to me in the background and they're on the Zoom and it's a whole thing. But in any event, we have the papers on Karen Reed's motion to compel the town of Canton to release Sergeant Goode's records. And thank you, be in trouble. Thank you, because I know you'd be able to find it if you could. And we have David Yannetti's new case, and we have the decision on the reply all email, which I have not covered yet because, as you know, if you've been watching me, I was in Hawaii and then I was in Boulder and now I'm back. So I'm back in business. However, I was not able to cover some things while I was away because, vacation, family, and all of that stuff. I think, I don't know if mainstream media has just ducked out of covering the Karen Reed civil hearings because the last hearing was so short. It was like 3 minutes. And oftentimes, Court TV and Law and Crime, Boston 25 has it live on their YouTube or on their website. Oh, please. And that's what they do. Sometimes they put it up last minute. Boston 25. YouTube. Thank you. I don't see Boston 25 News. The last live stream I have from them on Boston 25 News YouTube is man convicted of brutally murdering Salem students. Hold on. Unless you're looking at an old one, Kathleen. Here's what I get when I look at Boston 25's YouTube channel. Here's what I get. Live. That's the last thing they have. Let me go to their website. I'm going to go into the Zoom just in case. If I find it, I will switch over. But right now I'm going to be quiet. I'm going to be quiet until I can find it. If you have the actual a real stream on YouTube, send it to me. That's not another creator. That's actually a mainstream media. It says no live streaming. No live streaming. I can't live stream it. Fanbase at mlittlelaw.com. If there's somebody else live streaming it, I can only listen to it as of now. If you are on the Zoom, please mute. They didn't start it yet, so I can talk for a moment. It's like they don't want us to watch. I know, I'm telling you. I'm not even kidding you. Not even kidding. Yeah, Boston 25 was like a month ago. Hopefully it'll be short and I can just report back to you. It's like they don't want us to watch, I know. But I'm going to show you what it says over here. See? I can't do it. I won't do it. I'm not going to get in trouble. Here's an article that you can read while I'm listening to the Zoom. Testing. Can you hear me? Can you hear me? I'm not on Zoom though, right? Okay. Is everyone on Zoom muted? Diller has conducted 0 depositions, but has noticed 11. Rosenberg has noticed, like, next Tuesday, first deposition. Notice means they've sent notice to the party to depose them and told them when and where to come, but they haven't been held yet. Next week and beginning of July, all of Karen's depositions are noticed, meaning that's when they told them to show up. Nobody has taken any depositions yet. 0. The first deposition is coming up next Tuesday. Judge is not happy. Judge Bill Day. Judge says, "I guess you all decided to ruin your own summers because none of you have done your depositions yet." Diller has a pending subpoena to Norfolk County DA relative to Aiden Carney's case. Carney's attorneys say they can't produce anything because there's a pending case. So they're gonna make a motion? So they want records from Carney's team about his criminal charges. Judge is like, "When are you gonna do that?" Oh, it's to Norfolk DA's office. Carney. And Diller wants documents from Norfolk DA's office on Carney, but there's protective orders in place. They met and conferred with the DA's office. Diller did. Huh. Judd is not happy. Okay. We're going to look at this motion in a minute. April 28th at 3 p.m. He says he may have to make another motion to MSP because they're not giving documents either. Hmm. Nobody wants to give anything. The judge is Gilday. He's mad. He's like, I'll tell you in a minute. Hmm. He's like, we haven't been able to move this along, apparently. Mm. We have depositions scheduled all summer. Judge is not happy. He says you should be done by 3 o'clock with the deposition. He's like, I doubt that. Oh, state police detective Tully. Tully on May 27th. Tully on May 27th. Oh, May 7th. May 7th. May 8th for status. No way. No way. He's being very calm, but he's not happy. Four parties. Not enough time for Tully. It's like 5 hours is enough time for Tully. They're like, yeah. Oh boy. Okay, well, the judge is not happy. Judge is not happy. First up, there was about, I don't know, 7 or 8 attorneys on there. It was like, it was like the Brady Bunch. I know. I feel like I'm like commentating the Masters. 7 or 8 attorneys on there. It's Judge Mark Gilday in Plymouth Superior Court. He's telling us everything. First thing the judge says is, okay, where are we with depositions? And Diller, I misspoke and said Rosenberg. Diller, the plaintiff's attorney for the O'Keefe, says, well, we've just noticed 11 depositions, but none have been conducted. A notice deposition is just when you send somebody a letter saying we intend, or a subpoena saying we intend to take your deposition on such and such a day at such and such a place. But we haven't done any. And the judge was not happy. And then he asked the attorney for Peabody and Arnold, and I forget who she represents. And she, I don't think they've noticed any depositions because really they're taking a back seat to Karen Reed, who's like the lead defendant. And they're basically going to go along with whatever Karen Reed's attorneys say. And so Rosenberg says, well, Your Honor, we told you about all the depositions we intend to take. And I think there was something like 40 of them. We've been over the list of depositions that they intend to take. And he said that the first deposition is upcoming and it's going to be next Tuesday. And that is when the judge said something like, oh, I guess you all decided to like ruin your summer because that's when you're going to be doing all of these depositions. And everybody was kind of silent. And then Diller said, well, Your Honor, we have an outstanding subpoena to the Norfolk County DA's office because we want information on the Aiden Carney case because we think a lot of that discovery is going to be relevant to our case. How is that relevant to Karen Reed allegedly striking John O'Keefe with her car and killing him in a wrongful death action? And then also, uh, how is that relevant to the intentional and negligent infliction of emotional distress against Kaylee, the niece? It's not. It's like, oh, it's right, exactly. And so, Rosenberg, so the judge was like, yeah, okay. The judge was not happy, but he was not screaming. He was just very quiet the whole time and like, okay, like I see that nobody's really done anything. And I've told you since I don't know when, however long this case has been going on, that I want this case to move, move, move. And you guys are like doing nothing. Rosenberg's motion that we're going to look at next to compel the town of Canton to produce documents pursuant to their subpoena about Sergeant Sean Goode is going to be heard on April 28th at 3 p.m. And to that, Rosenberg said, well, Your Honor, by then you might have another motion that I'm going to file because Massachusetts State Police is not giving me any of the documents that I subpoenaed from them either. And so I think we're going to have a motion. You can probably hear that motion at the same time. And the judge is like, yeah, okay. In the back of his head, he's thinking, just get the flipping depositions done. Like, how long am I going to have this case on my docket? I don't want it anymore. And so then the judge said, okay, when can we come here for a status conference? How's May 7th for everybody? And May 7th, Rosenberg said, we have a deposition that day, Your Honor. And he said, of who? And he said, of one of the Massachusetts State Police detectives, Brian Tully. And so he said, well, can't we do it at 3 p.m. on the 7th? Because you should be done by 3 p.m. And Rosenberg is like, yeah, I don't think so. And the judge is like, well, 5 hours to depose him, Tully, seems like it's enough. And Rosenberg's like, yeah, no, he's probably going to have Tully on the stand for like 3 days. And so I think they decided they put it on for May 7th at 3 p.m. And the judge said, well, that should give you incentive to get it done in 5 hours. And I think Rosenberg was kind of like in the back of his head, no, I'm going to keep him here for 3 days. So did they eventually put it on May 8th? I'm not sure. So it's either May 7th or May 8th. I have both written in my notes, but I think he said May 7th at 3 p.m. And then I guess if they're not done with Tully's deposition on that day, it'll be on May 8th. So I don't know what happened if anybody tried to stream it, but maybe they got taken down. Maybe not. I wasn't going to risk it. I'm just reporting it to you as if we're doing the Masters. In fact, I couldn't find my green shirt today, but I think I'll wear my green shirt tomorrow for the Masters. And now we're going to take a look at the motion. Thank you. Known under 3 for gifting 5 memberships. You're amazing. He kept it on 5-7 at 3, right? Because I have both written down. Hard and I'm listening to you and listening to them and like trying to make sure that none of you were on the Zoom unmuted. You guys did great, by the way. You guys did great muting yourselves on the Zoom. I don't think anybody heard my voice because, they totally would have called me out on it. Like, I see Melanie Little's here. She's talking, even though I didn't stream the hearing. I was a good girl. And so this is the Plymouth County case. And here's the caption for that one. It is the O'Keefes versus Karen Reed. And that's what this motion was for. Let me make this a bit bigger so that we can go through it together because we haven't looked at this yet. Oh, but the first thing that I need to tell you about is everything just disappeared, is the decision on the motion decision on the motion about the reply all email. Do you remember that one? You guys remember that one? The reply all, Karen replied all to an email. And Mark Diller said he was not going to delete it because he wanted to use it against her. And so a motion had to be made by Karen's team about whether or not Mark Diller should be allowed to use the reply all email. And we don't know what it says, but it's under seal with the court. Let me just flip this thing around here because it is sideways. Can I flip this around? I don't know. Full screen. But I don't think we've been over this yet, so we have a chance to do this now. Here we go. Here's the order on the reply all email. I'll make it bigger for you. Oh, look, we can rotate it. Yay. There it is. Nope, that's not rotated properly. Hold on. The normal orientation. Okay, here we go. Here it is. And the decision came down, or he decided this on March 27th, which is not too long ago, but we haven't covered it yet. And here's the decision on that. And it's just a notation on the original motion papers. March 27th, 2026. As noted in the Charm case, a client who seeks to preserve the attorney-client privilege has a responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Although this defendant did not meet that responsibility, the importance of the attorney-client privilege in our legal system outweighs that failure. Defendant's motion seeking deletion of the email and any copies is allowed. So they must delete Karen's reply all. Although plaintiff's concern about potential use of the email for impeachment purposes may appear to the defendants as unfounded, if such concern becomes reality, the issue is preserved as the email remains under seal with the court. So, and that is XOXO, Mark C. Gilday. And he signed off on it. So it doesn't mean they're not going to be able to use it later if it conflicts with whatever she says, if they need to use it for impeachment. However, they must, as of now, delete it. It remains under seal with the court, and they're not allowed to use it unless and until the judge says so at a later date. And so that was dated March 27th of 2026. I found that motion to be completely unnecessary because lawyers deal with each other all the time, and they're courteous and they grant each other the courtesies, especially when something involves the attorney-client privilege. Like, that's no joke. Okay. The fact that Diller fought this is wild to me. It's wild to me. First of all, it teaches all of us a lesson. Don't ever copy your clients on any correspondence. I never have. I never would. I never will. Because this is exactly the risk that you run. It was, according to Rosenberg, one-time thing. It was an error. Karen did it. She didn't realize she did it. And all of that is well and good, but it is a good lesson for everyone. And there's even case law in Massachusetts that's kind of on point about this very issue. And it did say that clients and attorneys both need to be very careful. And as you recall, Mark Diller's argument was that, listen, the case law said so. They weren't careful. And so she should be penalized. Right? And so there's that. Exactly. You send the email and then you forward it to your client if you need to. I am a big believer in the clients really don't need to have an entire copy of their file. Okay. Because clients that micromanage are every attorney's worst nightmare. Although Karen is very, very involved in her own case, and that's great. She knows her own case better than anyone. And that is her prerogative to do so. But this was a mistake. It shouldn't have happened. And luckily, the judge found in Karen's favor because there was no guarantee that it was going to go that way. But there also, is common courtesy among attorneys. And the fact that Diller wouldn't even agree to do so just speaks volumes to his character as an attorney. But that's my opinion. And right now, I'm sticking to it. All right, let us close this one and get to the next one over here, which is the motion that we are here to talk about that will be argued now on April. We're already in April. What did I say? April 27th. April 28th at 3 p.m. But once again, it's going to be like a whispering sort of commentary because, as I showed you, this court does not allow live streaming or restreaming of anything in this courtroom. So I don't know why. Courtrooms are supposed to be open to the public, and there is a lot of public interest in this case, but apparently they don't want us to see anything. Let me make this bigger for you so that we can read it together. Something in retrograde or something. Nothing wants to, the technology does not want to cooperate today. All right, here we go. This is defending Karen Reed's motion to compel the town of Canton to produce documents pursuant to a non-party subpoena. And this was filed on, well, it was filed today. No, yesterday, April 8th. But the way it works in Massachusetts is that you file them, you serve the motion on the other side, and then the other side opposes your motion, and then you can reply to the motion. And once all of those things are done, only then does it become filed with the court. So actually, this motion was served on the plaintiffs by defendant Reed on or about March 23rd, 2026. But just filed with the court yesterday. Okay, so let's read through this. Please explain the deposition process, each side done separately. So if a person is on both lists, you have to have 2 depositions. No, not in one case. So they've given a list of all the depositions they want to take. Karen's team has, and there's something like 40 of them. We've been over the list. And so if they do a deposition of Tully, then everyone questions Tully. He doesn't come in twice for a deposition unless there's another case. Like in the federal case, he may have to be deposed twice because Karen Reed sued everybody. The Haas defendants moved it to federal court, and so he may have to be deposed twice. Because initially when Karen Reed wanted to bring all of the House defendants and all of the MSP people and Proctor, Tully, Buchanan, everyone into this particular case, they took the temperature of the judge, and the temperature of the judge was like, yeah, I don't think I'm going to allow it. And so she instead just filed a separate action in another county. And then the Haas defendants removed that to federal court. It's a whole different action. So the purpose for consolidating these cases would be exactly for that reason, so that the defendants or third parties would not have to be deposed twice. But for this particular case, which is the O'Keefe's versus Karen Reed, CF McCarthy's, and the Waterfall, each person will be deposed once, but everyone can ask questions. Does that make sense? It's a great question. Thank you, Suti78, for your 5. Bridget said, thanks for covering. Thank you, Bridget, for your 5. Gigi's engraving all the silver bracelets and said, my granddaughter Leighton ran in here when your song started playing and said, Miss Melanie is on, Gigi. She's hooked. Oh, I love her. I love Leighton. Thank you. Thank you for your 5. Maximum Bacon says, maybe I shouldn't be, but I am honestly shocked. 0 depositions at this late date. How or why? Your guess is as good as mine. But the funny thing is, I mean, if you want to call it funny, not like funny, haha, but funny, ironic, is that the first deposition that's going to take place in this exact case of O'Keefe versus Karen Reed and the McCarthy's and Waterfall is a deposition noticed by Karen Reed. That the plaintiff has taken 0 depositions. And remember, only Karen Reed's portion of this case was stayed during the pendency of the criminal trial. And so the plaintiff was supposed to be doing discovery during that entire time, but didn't. I have an entire playlist on this case. You can look for it. It's under O'Keefe versus Reed, the civil cases, and there's a lot of content. We've been over mostly every pleading in this case. And it is shocking. It is shocking that the plaintiffs have done 0 depositions. But at least now we know that Tully will be deposed on May 7th. Thank you for your 10, Maximum Bacon. And Bridget said, this is like a suspense movie and we're all waiting till the end. Popcorn pop, no better yet. Oh, did anybody watch the Masters par 3 tournament yesterday with all the kids of all the players playing golf? It was so cute. Thank you for your 10, Bridget. I don't know why that reminded me of that. And Nona 3, thanks for gifting 5 memberships. You're amazing and awesome. And Sue, I answered your question. So let's move on. I'll make this bigger and myself smaller so that you have maybe better ability to read. Defending Karen Reed's motion to compel the town of Canton to produce documents pursuant to a non-party subpoena. Karen Reed respectfully requests that the court compel the town of Canton to produce all documents that are responsive to the subpoena that Reed served on it over a month ago, a copy of which is attached to the accompanying memo of law. That subpoena seeks documents relating to the Canton PD's investigation into Sergeant Sean Goode. Goode's alleged misconduct, which led to him being placed on administrative leave in late 2025. Reed's counsel has been conferring with the town's council in good faith for months about these documents. Initially, the town council expressly represented that the town did not possess documents that are responsive to Reed's subpoena, but now, months later, surprise, the town acknowledges that it does in fact have documents, but it objects to producing them. However, the town has not asserted any objection that justifies withholding the requested materials, and its conduct further delays the party's ability to move this litigation forward. The documents that Reed seeks are well within the scope of Rule 26, and the court should order the town to comply with Reed's subpoena. Wherefore, Reed respectfully requests that the court allow this motion and order the town to produce all documents responsive to Reed's February 10th, 2026 subpoena within 10 days of such order. Well, they subpoenaed it on February 10th. The town of Canton's like, we don't have anything. Oh, wait, but now we do. But we don't think that you should be able, we should have to turn it over to you. And we're not even going to tell you why. So that's the initial motion. Then there is also a memo of law that accompanies it that we will take a look at. And this is a defendant Karen Reed's memorandum of law in support of the motion to compel the town of Canton to produce documents pursuant to a non-party subpoena. Let's see if they're going to tell us anything. That's right, Scott McGinnis. Canton Police Sergeant Goode's involvement was exposed via now fired Massachusetts State Police Trooper Michael Proctor. His full phone record extractions. Yeah, let's see if they tell us anything else. It's a cold read for me, so don't tell me because I've been on vacation. And so I might have missed some things, but I like to have a real-time reaction for you. So let's see if we can do that. Defendant Karen Reed respectfully requests, and this is everything that we just read here. Town of Canton compelled the town to produce all documents pursuant to the subpoena. That subpoena seeks documents relating to the Canton Police Department's investigation into Sergeant Sean Goode's alleged misconduct, which led to him being placed on administrative leave in late 2025. Reed's counsel has been conferring with the town's council in good faith for months about these documents. Initially, they said they didn't have anything, but now all of a sudden, poof, they do have documents. They're objecting. They're not asserting any objection that justifies withholding the materials, and its conduct further delays the party's ability to move this litigation forward. Documents that Reed seeks are well within the scope of Rule 26, and the court should order the town to comply with Reed's subpoena. Here's the argument. Reed has now served 2 subpoenas on the town seeking documents from Canton PD. Reed served the first subpoena on the town in July of 2025, and the town produced certain Canton PD records in response. That response is not being challenged here. However, in the fall of 2025, Reed learned that Goode had been suspended from the Canton PD after Reed's acquittal and that the town was investigating him for alleged misconduct. The town's investigation into Goode's conduct is relevant here because he was working the night John O'Keefe III, Mr. O'Keefe, died, answered the 911 call reporting Mr. O'Keefe's death, was one of the first police officers on the scene at 34 Fairview, testified at Reed's criminal trial, and was a close friend of Michael Proctor's, the lead detective who investigated Reed, as well as individuals that were in the house on the property where O'Keefe's body was discovered, and their family members. Wait. Goode answered the 911 call reporting John O'Keefe's death. I mean, I remember that he answered the phone when Carrie Roberts called in after Karen called her freaking out, and he answered the call and they joked about a blizzard party and he said he wasn't invited. But I didn't remember him answering the 911 call where Jen McCabe said there's a man passed out in the snow. She did talk to him? I must be losing my mind. All right. Thank you, Glamasseuse. The one where she said there's a man passed out of the snow. There's a man unresponsive in the snow. Okay. I totally forgot. Okay. Quite possible. Was he the one that told Dever to stay? Yeah, I think so. I think he was. Right. And then he called Dever back to the station. Okay. All right. I have too many cases in my head. According to media reports, Goode's post-criminal trial suspension was based on his interactions with Proctor, footnote 1, which says, see, for example, Canton police officers' alleged misconduct stems from Michael Proctor investigation. I-team sources say, CBS News, and then here's a hyperlink to a CBS News article. That was November 3rd, 2025. And Canton Police Sergeant Sean Goode suspended for misconduct allegations as department faces turmoil after Karen Reed trial in the Boston Herald. And that was November 3rd of 2025. Shortly after learning of Goode's suspension in December of 2025, Reed's counsel contacted the town's council to determine whether the town would produce documents relating to its investigation pursuant to Reed's first subpoena. In a phone call, the town's council informed Reed's counsel that the town did not have any documents relating to the investigation or Goode's alleged misconduct, other than the letter placing him on leave. When Reed's counsel repeatedly attempted to confirm that representation in writing over the course of several weeks, the town's council refused to respond. Really, they wouldn't put it in writing? That's interesting. They said all they had was the letter placing him on leave. That's interesting. Later, other attorneys representing the town informed Reed's counsel that the town may, in fact, have additional documents related to its investigation, but that the existing subpoena did not specifically cover those documents and that the town would object to producing them in response to that subpoena. Okay, they wanted a more specific subpoena. So then Reed's counsel served a new, more specific subpoena on February 10th of 2026. A copy of that subpoena is attached as Exhibit A. In the context of Rule 9C conferences, Reed's counsel proposed that the parties discuss a compromise whereby the town would produce at least some of the relevant documents or produce documents subject to confidentiality restrictions to address the town's concerns about its ongoing investigation. The town's council represented that he would consider this proposal, but he never followed up except to send a standard Rule 45 objection letter and continued to refuse to produce a single additional document. Oh, the town again. And the Canton PD does not want to tell us anything. It must be really, 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 really bad. Must be really, 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 really bad, huh? As it stands now, the town objects that Reed's requests for documents relating to the investigation into Goode's misconduct are overbroad, that those documents are irrelevant, and that it will not produce documents related to an ongoing internal investigation. The court should reject the town's objections. In this case, plaintiffs allege, among other things, that Reed created a false narrative that the police investigation into O'Keefe's death was corrupt, biased, and designed to frame Reed. Well, I mean, listen, if you bring these allegations, right, if one of the onuses of the complaint is that Karen Reed created this false narrative that the police investigation into O'Keefe's death was corrupt, biased, and designed to frame Reed, the only way she can defend against them is to prove that it actually was not a false narrative, right? And so in order to prove that the investigation was corrupt, biased, and designed to frame her, she's entitled to these documents, because we still don't know why Goode was forced into suspension, right? Goode's conduct is directly relevant to this issue because he played an important role in the initial response to Mr. O'Keefe's death and, as a result, Reed's criminal prosecution. He answered the originating 911 call. He was one of the first police officers on the scene and testified at Reed's first criminal trial. All right, just to refresh my recollection, chat. The first 911 call of Jennifer McCabe went to like some other dispatch, right? And then it had to be transferred to Canton, right? So that's why it sounded like first she said there's a man PS out in the snow. And then she said there's a man unresponsive in the snow, right? So the first person that she spoke to was like a main dispatch number. And then she was transferred over to Goode. Right. And Goode was shot home to get his leaf blower and then shot back because Gallagher said, do you have a leaf blower in your garage? You live close by, even though Canton PD was like 1 mile away. And so he shot home, he got his leaf blower out of his garage, he shot back. And then the only video we have from the scene is of Gallagher using the leaf blower to blow snow away and find a clear glass. Yes. Oh, yes. Oh, yes. Oh, yes. That's right. It went to state and then it went to local. Thank you, Gina. I can't be expected to remember everything. I mean, I remember most things. In my defense, I do remember most things. And I have a pretty good memory for the details. But sometimes it happens. No, it was good. It was Sergeant Goode. He shot home. He shot back. He got the leaf blower. Gallagher used it, but it was Goode's leaf blower. Goody went to get it. Goody went home and he got it. Right? It wasn't Lank. Somebody said it was Lank. It wasn't Lank. It was Goode. Goody. All right. Moving on. Goode was also a close friend of the lead investigator, Michael Proctor, and Goode's alleged misconduct is reportedly related to his interactions with Proctor. In fact, according to newly received documents from the Norfolk County DA's office, Goode and Proctor are close longtime buddies who frequently exchanged vile messages while both served as police officers. Oh, tell me more. Tell me more. I'll read that again. In fact, according to newly received documents from the Norfolk District Attorney's Office, Goode and Proctor are close longtime buddies who frequently exchange vile messages while both served as police officers. Well, remember, okay, just to recap for you, Proctor in the Miles King case was forced to turn over his phone to the DA's office because Rosemary Scapicchio, one of my spirit animals, said, because she represents Miles King, Your Honor, because Michael Proctor said such horrific, vile things about Karen Reed that were totally biased and prejudicial to Karen Reed, my client, obviously, he said things about my client too, and so I should be entitled to a phone extraction, right? And so Judge Krupp said, okay, well, you can have it, but I'm going to limit it to a certain date or something like that. And then Michael Proctor's attorneys came in and said, Your Honor, listen, Michael Proctor has no problem giving his phone up. But the thing is that in February of 2024, he set his phone to delete everything every 30 days. And so therefore, you're not going to get much of anything. And then it was, I think, Judge Doolin who said, okay, well, I'm not going to limit this to any time period or anything. So go ahead, do your thing. Do your thing. And so the Norfolk DA's office extracted the phone and lo and behold, surprise, the setting didn't work. And they retrieved something like everything in Proctor's phone going all the way back to something like 2012 or 2013. And so everything is in there. And that is what they're referring to here when they say newly received documents from the Norfolk DA's office show. I mean, Proctor has worked as an MSP trooper, I believe, since, correct me if I'm wrong, 2012 or 2013. Okay, they posted the Zoom meeting. That's great. There's nothing to watch other than what I already told you. So if you guys want to go watch it, you can go watch it later. But what happens when you post things like that is that it takes people away from the stream to go watch it, and it's just not whatever. I can't explain rules to people. Apparently they've been communicating for years. I forget how long Goode has been on the force for. But maybe for 12 or 13 years they've been exchanging vile messages, and who knows what else. Who knows what else? Right? Thus, documents related to the town's investigation into Goode are relevant to the claims and defenses in this action and discoverable, according to Rule 26B1, which is quoted here. Moreover, the town's assertion that the requested materials relate to an ongoing investigation is not a valid basis for refusing to comply with a subpoena. The town's investigation is an internal personnel matter, not a criminal investigation in which disclosure could risk jeopardizing a prosecution. Indeed, the town's objection letter does not explain how producing the requested documents could interfere with its ongoing investigation into Sergeant Goode. Moreover, documents related to internal investigations of police officers are discoverable and must be produced in response to subpoenas. Based on Judge Gilday's demeanor today, he's not going to be happy with the town of Canton the town of Canton lawyers. Like, they know they're required to produce it. If you have it, produce it. It must be really, really, really bad for them. And here are some cases that are cited here talking about how they got approved, how they have to turn over that stuff, internal affairs files. Documents relating to the internal investigation into Goode's conduct are therefore properly subject to read subpoena, and the court should order the town to produce them. Conclusion: for the foregoing reasons, Reed respectfully requests that the court order the town to produce all documents responsive to Reed's February 10th, 2026 subpoena within 10 days of such order. XOXO. Aaron Rosenberg, Seligson, all the rest. Alan Jackson, and all the rest. And everybody else. And this is signed March 23rd. So this is when they served it on the O'Keefe's attorneys. And here is Exhibit A, which is a copy of the subpoena that was sent to the keeper of records of the Canton PD, asking for all the documents in Schedule A by February 23rd. And here's what they're looking for. Here's the definitions. Instructions. This is all just basic subpoena form type stuff. Here's what they want. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages concerning any disciplinary investigation of Sergeant Sean Goode. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages concerning any report about, complaint concerning, or alleged misconduct committed by Sean Goode. I mean, if they're saying this is overly broad and unduly burdensome, how many complaints are there against Sean Goode? And how many disciplinary investigations are there against Sean Goode if the contents are so voluminous? And that's their objection, but still it's not a proper objection. Number 3, all documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages concerning the Canton PD's and town's investigation of alleged misconduct committed by Sergeant Sean Goode, which began in or around the fall of 2025. 4, documents sufficient to identify the third party or third parties who are conducting the investigation of alleged misconduct committed by Sergeant Sean Goode, which began in or around the fall of 2025. Everyone hit the like button. Thanks, Hank's Tie-Dye. Thank you, Hank's Tie-Dye. You guys have the best usernames on the internet. Thank you, Tara Queenbow says Goode has been at Canton PD for 18 years, so longer than Proctor's been with the MSP. Correct? Thank you. Hold on a second. I don't know who this is. Is it a troll? Wait, hold on. No broken taillight was found under John O'Keefe. No, Donna, it absolutely was not. All right. All communications between Sean Goode on one hand and Michael Proctor, Kevin Albert, Brian Albert, Nicole Albert, Chris Albert, Julie Albert, Colin Albert, Brian Higgins, and Jennifer McCabe, Matthew McCabe, Allison McCabe, or Kerry Roberts on the other from January 28th of 2022 to present. I mean, is it so voluminous that it's unduly burdensome for the town of Canton to produce any communications between Sean Goode and any of those people? Michael Proctor, Kevin Albert, Brian Albert, Nicole Albert, Chris Albert, Julie Albert, Colin Albert, Brian Higgins, Jennifer McCabe, Matthew McCabe, Allison McCabe, Kerry Roberts. Oh. And the walls come crumbling down. And that's the subpoena. Judge Gilday is not going to be happy. Let's take a look at their opposition to see how they could possibly oppose this, because they did. Town of Canton filed an opposition, and here it is. Sorry, Donna. They sneak in and they stay here for 48 hours so that they can. Well, they need a flatbed. The trolls come in and they stick around for 48 hours just to wait to come in and troll. They are nothing if not tenacious, right? Those messages. Thank you, Pierre. Double D says, I really hope all these people involved with this framing are held accountable. I'll allow it, Cy. Thanks for being here for 19 months. Says, would love to jump into David Yannetti's new case. Thank you very much. We're going to take a look at that after we finish here. Hi, Romy. Thank you for your cupcake emojis. And thanks for being here for 15 months. And I haven't seen you in a while. Good to see you, girl. Nicole says, Nicole Ray, like Do Ray Me, says, who came up with the idea of not going outside when John was found? Who would think that it is common sense or a logical lack of response? An experienced officer's home? I'll never get over it. Thanks for your 10. You know what I'll never get over? Pulling up to your sister's house, finding your dead friend's body on the lawn, and not running inside your sister's house to make sure everybody's okay. I will never get over that. Never. Because if that was my sister's house, that would be the first thing I would do after calling 911 or while calling 911 would be to run into the house to make sure my sister and her family were okay too. Because having no idea, allegedly, how John O'Keefe died or when, wouldn't you run into the house to make sure that there wasn't a sniper? But now we know that Jennifer McCabe called her sister very early in the morning, around 5:07 or so. I don't remember the exact time, maybe twice around those time periods, and doesn't remember calling her at all, but it was something like, I don't know, 22 seconds long. Did she already know that her family was okay? I mean, come on. This case is a lot bigger than just John's death. That's right, Scott. Thank you, Nicole. Thank you for your 10. And that's one thing I can't get over. And I don't believe that she also didn't remember those calls and that her sister didn't answer. So, right. Especially since her sister, right. Especially if your sister didn't answer. Wouldn't you run even faster into the home if your sister didn't answer? I know I would. Especially, Marcello says, especially because Brian Albert was a Boston PD cop too. Maybe not. He wasn't even Boston PD. Wasn't he part of the what was the name of his? You know, like he went and just after the dangerous criminals, organized crime task force or something like that. Dealing with dangerous people, every fugitive task force. Thank you. Or organized crime task force. I'm thinking of the fugitive task force, dealing with dangerous killers every single day. Couldn't he be targeted? Wouldn't you run in there first thing? And if Jen was trying to get Nicole on the phone, why not call Brian? She had no problem calling him when the FBI showed up. Right. Or Brian Jr. Right. All right. Here's the opposition. Let's see what the town of Canton has to say to this. Hold on one second. Town of Canton's opposition to defending Karen Reed's motion to compel the town of Canton to produce documents pursuant to a non-party subpoena. And here is what they have to say for themselves. As relayed in the town's initial objection to the defendant's subpoena, the defendant's subpoena is overly broad, not reasonably limited in time or scope, is not reasonably tailored to produce discoverable information, seeks records and information that are wholly irrelevant to the underlying claim, is unduly burdensome, and seeks materials and documents protected by attorney-client privilege and or the attorney work product doctrine. In further support thereof, the town asserts the following. We just read the subpoena, and if that's unduly burdensome because there's so many communications between all of those people and Sergeant Goode, and he has so many internal investigation reports, that's wild. But number two, it was between January 29th, 2022 and the present. It's not unduly burdensome at all, in my opinion. But let's go on with your bad self and tell us what you have to say for yourself, Town of Canton. Factual background. As acknowledged in the defendant's motion, the defendant previously issued a subpoena to the town and numerous other non-party entities in July of 2025. The town produced numerous records in response to that extensive request. Months later, however, in late November of 2025, the defendant began contacting the town and town council seeking new records related to Sergeant Sean Goode being placed on administrative leave by the town. The town placed Sergeant Goode on paid administrative leave in late October of 2025 and coordinated with town council to retain an independent third-party investigator to conduct an internal affairs investigation on behalf of the town. Wow. So they got an independent third-party investigator to investigate Sergeant Goode. Because finally, for the first time ever, they're probably realizing that they have a conflict here. Shocking. Right. I had the same question, Grace Base. Are there complaints about Goode going back for a long time because everything else was limited in time? Mm-hmm. On or about December 5th, 2025, the town council and defendant's counsel spoke via telephone regarding the administrative leave and pending investigation. Town council advised defendant's counsel that the only document which town council was aware that would be responsive to defendant's counsel's request was a letter placing Sergeant Goode on administrative leave. On or about December 12th, 2026. Well, are we in the future now? On or about December 12th of 2026. I mean, I guess that's supposed to say 2025, but the judge shouldn't have to guess. Does anybody proofread in the state of Massachusetts, Commonwealth of whatever the hell you call yourselves? Does anybody proofread there? That was a rhetorical question. On or about December 12th, 2026, town council produced documents to defendant's counsel, a copy of the notice of placement on paid administrative leave letter issued to Sergeant Goode. Well, because there's certain hoops they have to jump through before they can suspend pay, as we know. Immediately after the letter was produced to the defendant, however, copies of the letter were posted online. Defendant's counsel then proceeded to send a barrage of emails to town council demanding attestations and declarations of what other documents may or may not exist. As was, are they going to blame? Are they blaming Karen Reed's attorneys for leaking that letter? Wasn't it like, didn't mainstream media, like, didn't Ted Daniel have a copy of that letter? I don't know. Are they going to blame YouTubers? I have no idea. Or Twidiots. A barrage of emails. How dare they? How dare they send a barrage of emails to town council? They proofread like they do investigations, says Sheila. Yeah, Ted had it like day one, says Andrew. That's right. I know, grammar and spelling, Diane. I am a snob of both. Exactly. As was relayed to the defendant's counsel at the onset, the investigation regarding Sergeant Goode has been ongoing. And so it's still ongoing? And while the town is not directly conducting the internal affairs investigation, records are generated and produced as the investigation develops. Oh, really? Okay. It's not done yet? The defendant's assertion that town relayed that it did not possess responsive records, quote, but now, months later, the town acknowledges it does in fact have documents, end quote, is deliberately misleading and offensive. It's offensive. The attorneys are offended. These are non-party attorneys right now, the town of Canton's attorneys. The town and its council operated in good faith to produce the limited responsive records it had in its possession, custody, and control to the defendant. However, as the investigation developed, the concerning timing of Sergeant Goode's administrative leave letter appearing online and defendant's counsel's improper attestation demands necessitated more formal objections to the defendant's request for investigation materials. Can I have some word salad emojis in the chat? I'm sorry. When somebody's trying to deliberately confuse you, they just put a whole lot of words into a sentence like that. However, as the investigation developed, the concerning timing of Sergeant Goode's administrative leave letter appearing online and defendant's counsel's improper attestation demands necessitated more formal objections to the defendant's request for investigation materials. Do they get paid by the word? Consequently, town council engaged in several discussions and email communications with defendant's counsel in which the town expressly objected to the defendant's attempt to expand its July 2025 subpoena and asserted that the newly sought materials were not responsive to that subpoena. Defendant's counsel agreed with the town's position and issued a new subpoena to the town on February 10th of 2026. Prior to the issuance of that new subpoena, counsel for the town and defendant engaged in discussion to narrow the scope of the requested materials so to not hinder or impact the ongoing Sergeant Goode internal affairs investigation. Why would it hinder or impact the ongoing Sergeant Goode internal affairs investigation? Held by an outside party. They sound paranoid. Exactly. Yada, yada, yada. Yada, yada, yada. In a flagrant contravention to those discussions, however, the defendant's February 10th, 2026 subpoena sought exceedingly broad records, namely, well, and we just read all four categories: all documents, video or audio recordings and communications, including but not limited to text messages and other forms of instant messages concerning any disciplinary investigation of Sean Goode. I mean, how exceedingly broad could it be? Regardless, it's all relevant and discoverable. We're in civil court now, my friends. We're in civil court. Right. Miranda says the length they are going to hide Goode makes me think it's real bad. Yeah, it's not so good for Goode. Not so good for Goode. Category 2, all documents, video or audio recordings and communications, including but not limited to text messages, emails, and other forms of instant messages concerning any report about, complaint concerning, or alleged misconduct committed by Sergeant Sean Goode. All documents, video or audio recordings and communications, including but not limited to text messages and other forms of instant messages concerning the Canton PD's and town's investigation of alleged misconduct committed by Sergeant Sean Goode, which began in and around the fall of 2025. He's definitely, Ashley, you guys are on point today. He's definitely not having a good year with an E at the end. Yes, we know. We know that Tully's deposition is set for May 7th because I listened to the hearing and then I reported on it. So we are aware. And the judge wants it done by 3:00 and he scheduled a conference for 3 and he thought that would give them incentive to get it done in 5 hours. And Aaron Rosenberg was like, yeah, I don't think so, Judge. It's not going to be done by 3. Tully's going to be on. Tully's going to be deposed for days because all the attorneys get to ask questions, not just Aaron Rosenberg, for days. 4, documents sufficient to identify the third party or third parties who are conducting the investigation of alleged misconduct committed by Sean Goode, which began in and around the fall of 2025. All communications between Sean Goode on one hand and Proctor, Kevin Albert, Brian Albert, Nicole Albert, Chris Albert, Julie Albert, Colin Albert, all the Alberts, Brian Higgins, Jennifer McCabe, Matthew McCabe, Allison McCabe, or Carrie Roberts on the other from January 28th, 2022 to the present. The town issued objection to the defendant's overly broad and improper subpoena on February 10th, 2025. Now we're going back in time. That should read February 10th, 2026. But like I said, nobody proofreads in the Commonwealth of Massachusetts. DEFCON 5 is the bullshit level. It just talks, but you can't hear it because of the mic. More than a month later, the defendant served town council with the incident motion. February 10th of 2025 was even before Karen Reed was acquitted. So, Roman 2, argument. The defendant's subpoena is impermissibly broad and seeks irrelevant materials. The defendant's motion suggests that it is simply seeking records regarding the current internal affairs investigation regarding Sergeant Goode. As detailed above, however, the actual subpoena in no way limits itself exclusively to the current investigation and seeks records for all documents concerning any disciplinary investigation of Sergeant Sean Goode. Well, yeah, because if he was disciplined before, it may show a pattern of conduct that Sergeant Sean Goode was up to no good, right? As well, it seeks all communications surrounding, and it doesn't mean that it's, first of all, okay, discoverable and admissible at trial are two totally different things. Virtually everything that could be argued to be relevant is discoverable in civil court. It may not be admissible at a trial. That would be up to a trial judge to determine, but it is definitely discoverable. And so this is all ringing hollow, but they probably know that. But again, they get paid by the hour if they're outside counsel for the town. And so good on them. Not a good track record, says Nicole. Melissa says, too bad Karen can't sell tickets to the depositions. It could wipe out her debt. Yeah. Exactly. The judge can't determine if it's admissible until it's all been discovered. Very good, Debbie Jo. Thank you. Thank you. Thank you. All right. Moving on as well. It seeks all communications surrounding any report or alleged misconduct of Sergeant Goode and communications between Sergeant Goode and more than half a dozen non-town employees for more than 4 years. Well, from the date of the murder of John O'Keefe to the present. Sorry if you don't like it, but maybe, just maybe, he shouldn't have used his personal phone the way he did with Proctor. You're no good. You're no good. You're no good, baby. You're no good. Thank you, Steve. Because, I think it's hilarious too. Bob Weir is here too. And he says, no good will ever be a cop again, in my opinion. I hope the McAlberts will pay his bills now. I don't know. Will he get a portion of the proceeds from the defendingthetruth.org fund? Because apparently Yuri Buchanan has a vested interest in that because, he was promoting that fund. Such requests are exceedingly broad and unduly burdensome upon the town and seem directly tailored to try to obtain attorney-client communications and or attorney work product materials regarding the current investigation. I'm sorry, what? None of the people that they mentioned that they want communications between Sergeant Goode, all the Alberts, all the McCabes, and Proctor, etc. None of those people are attorneys. How would the attorney-client work product apply? Your guess is as good as mine. And according to all the case law that we saw in the original motion, internal affairs investigation reports are completely and 100% discoverable. They're not privileged either. The defendant's motion makes no attempt nor sufficiently establishes the need for such miscellaneous records not related to this current Sergeant Goode investigation or the town's internal communications and documents regarding appointing an independent investigator. Even if, arguendo, the defendant's subpoena was limited to only materials regarding the ongoing internal affairs investigation regarding Sergeant Goode, the town fails to see how any such records are even remotely relevant to the allegations and defenses in the instant action, but relevance is not a proper objection in civil court. Like I said, the defendant's motion fails to articulate any relevancy whatsoever. It simply insists that Sergeant Goode was one of the initial responding officers to Mr. O'Keefe's tragic death on January 29th of 2022 that Sergeant Goode and Michael Proctor are close longtime buddies and merely conclude somehow that the documents related to the town's investigation into Goode are relevant to the claims and defenses in this action and discoverable. However, the current investigation, which did not even begin until nearly 4 years after Mr. O'Keefe's death, does not involve any allegations remotely related to Mr. O'Keefe's death, the defendant, and or Sergeant Goode's involvement with the investigation surrounding Mr. O'Keefe's death. Okay, are we just supposed Ipsy Dixit because you say so? Are we just supposed to trust you? Is it like, bro? Take my word, bro. Take my word for it, bro. Trust me, bro. What they're saying here is that Sergeant Goode's current suspension has nothing to do with anything remotely related to John O'Keefe's death or Karen Reed or Sergeant Goode's involvement with the investigation of John O'Keefe's death. Do you believe it? But even if it shows bias towards other defendants, sharing of nudes, it can also show a pattern of conduct of Sergeant Sean Goode and others. And if he was communicating with any of the people who may have, certainly should have been, in people's opinions, considered suspects, all of that could become relevant to Karen Reed's claims that it was not a false narrative, that she was framed. Any records in town's possession regarding the current investigation are irrelevant to the instant action, and the defendant fails to articulate any relevancy or need for such records. B, the defendant's subpoena would negatively impact an ongoing investigation and seeks records that are obtainable through other means and or already in the defendant's possession. I don't know how they would be in the defendant's possession. Any text messages between Goode and the Alberts or Goode and the McCabe's, or they wouldn't have that stuff. But let's hear what they have to say about it. The internal affairs investigation regarding Sergeant Goode is still ongoing and is not yet concluded. The defendant's subpoena seeks all documents in the town's possession regarding the investigation and internal communication records, amongst other irrelevant materials, the disclosure of which could have serious ramifications and impacts upon the investigation. Not if it's under a protective order. If investigation materials and internal communications were disseminated to potential witnesses or Sergeant Goode himself, it could prejudice or otherwise complicate pending interviews. Wow. They've been investigating this for a long time. They've been investigating this since October. Yes, law and disorder. Are they daring a FOIA request? Get on it right now. Get on it right now. It's been 6 or 7 months that they've been investigating this still, and they still have pending interviews? They think we're stupid, said Jane Cheeseman. This concern is particularly apparent as records already produced to the defendant were then immediately posted online on various social media accounts. At the close of the investigation, the town anticipates having an investigatory report and or summary regarding the investigator's findings and conclusions. As is asserted by the defendant, barring any statutory exemptions, that report would generally be considered a public record and readily accessible to the defendant via a public records request. Oh, really? Are you saying they shouldn't be able to subpoena you for the records, that the defendant should FOIA the records from you? Oh, really? Are you seriously going to make that argument for the world to hear about? There's over 4,800 of you here right now worldwide, and you are now listening to this ridiculous assertion. Wasn't that great? Yeah, I loved it too. When the judge said, you all want to ruin your summers by not getting any of these depositions done. Yeah, because they're going to have to do them all summer long, Sheila, all summer long. The defendant has not articulated any grounds for the immediate necessity of these records or why the defendant receive investigative records prior to the conclusion of the investigation or the drafting of any investigatory report or summary. In lieu of a compelled subpoena, the defendant can simply send a public records request upon the conclusion of the investigation. That's hilarious. That's hilarious. Really? Really? You're going to ignore a subpoena and tell them to just file a FOIA request? I don't think Judge Gilday is going to take kindly to this. What do you think? What do you think? It also appears that the majority of the information sought by the defendants has already been obtained by the defendant. The basis of the pending investigation involved text communications involving multiple individuals, including Sergeant Goode. Okay, wait a second. Hold on. They're telling us something now. The basis of the pending investigation into Sergeant Goode involves text communications involving multiple individuals, including Sergeant Goode. So they're group text messages that Goode was on, huh? Tell us more. Those text communications are at the heart of several other pending matters and are subject to protective order. Okay, so you mean the group text messages with Goode and others involving Miles King and those other collateral cases? That's right. Allison says we have no quit. Remember, don't dare us. The defendant's motion appears to assert that the defendant has already obtained these text communications as newly received documents form the Norfolk District Attorney's Office. Well, doesn't mean that that's everything. Just because they got Proctor's phone dump doesn't mean that that's everything involving Sergeant Goode. Sergeant Goode could have been communicating with these other people on the side. Wow. But okay. Thus, the town's investigation into these text communications seems irrelevant and immaterial if the defendant already has access to and possession of those documents. Trust us, bro. Conclusion. This is not the first subpoena the defendant has issued to the town in this instant action. Right, because the first subpoena that they issued to you was before it was announced that Goode was placed on leave. The town, through its counsel, has engaged in continuous good faith discussions with the defendant's counsel to avoid motion practice and discovery disputes for a claim in which the town is not a party. Well, not yet. After 6 months passes, you're going to be a defendant in Karen's federal case. The defendant's barrage of demands for irrelevant town records during the pendency of an internal investigation started years after the death of John O'Keefe, however, has necessitated the town's objections. The defendant's February 10th, 2026 subpoena and repeated demands for pending investigation materials are improper, seek irrelevant records, and was issued in bad faith due to the defendant already having possession of the underlying text communications. No, Proctor's text messages are not the same as Sergeant Goode's text messages, right? Yeah, but remember, says that girl T, they're not corrupt. Norton Cancellation says, good faith, in air quotes. It is. They doth protest too much. They doth protest too much because it makes me think they're really, really hiding stuff when they protest this much about stuff that is clearly discoverable. Okay, whether or not it's admissible is another issue, but it is discoverable. But they're telling us that the investigation, the independent investigation into Sergeant Sean Goode and his conduct is not even yet concluded. It is still ongoing, according to them. Trust me, bro. The town already responded to the extremely extensive subpoena issued by the defendant in July of 2025, and there has to be some logical and appropriate restrictions upon the defendant's continual demands for records from the town. Why are you hiding it? He was suspended after July of 2025, and you know it. The town maintains that disseminating internal affairs investigation materials at this time is improper and harmful to the pending investigation. Because they said they don't want Goode to find out about it. The defendant's subpoena is overly broad and is moot, given the records already obtained by the defendant by third parties. Come on, really? Are you really in good faith going to make that argument? That Goode's phone contents and Proctor's phone contents are one. How could you really make that argument in good faith? The court therefore must deny the defendant's motion to compel, or at the very least, significantly narrow and limit its scope in order that any such responsive record be issued under a seal and or a protective order. And then it has the gall to say respectfully submitted on behalf of the town of Canton. Here's the law firm, Clifford and Kenny, LLP. Somebody tell me. I mean, of course, they're outside counsel. David, I'm going to butcher the last name. Kouroyen, Kouroyen, and Chris Kenny, Esquires of Clifford and Kenny in Pembroke, Massachusetts, dated April 2nd, 2026. Yes, and they don't respond to records requests until you file a lawsuit for them. Queen Corey learned the hard way. Yes, she did. Yes, she did. And then they served this on Aaron Rosenberg on April 2nd of 2026. But wait, there's more, because Karen Reed's team, of course, needs to have the last word, as they should, and filed a reply to this to clap back and get the last word. Let's see. Reality with Kristen Marie. Thank you for your 20. Says 2 things that make me sick. 1, accusing Karen of causing emotional distress. As the very people allegedly caused his death, I have ingratiated themselves into all their lives as the state outs them. They through 2 unwinnable trials. Thank you, Kristen Marie. And thank you so much for your 20. And also thank you, Kristen Marie for becoming a new member. And Christine Mitchell says, I love your hair today. It's golden and curly. Oh, thank you. Thank you so much. Thanks for tuning in from across the pond. Let's take a look. Thank you, Kyla, so much for your Venmo. You're a sweetheart. I appreciate you so. Oh, she says, thank you. You're welcome. All right, let's take a look at the reply. And as we heard from the judge, this is going to be argued, this motion, on April 28th at 3 p.m. And here's the reply. Defendant Karen Reed's reply in support of motion to compel the town of Canton to produce documents pursuant to a non-party subpoena. The limited documents Reed's subpoena seeks are directly relevant to this case and well within the scope of discovery. Producing them will not unduly burden the town. As the court knows, Reed was tried for and acquitted of the murder of John O'Keefe III. She argued in her criminal defense that she was framed and that the investigation was corrupt, biased, and otherwise tainted. Plaintiffs are now suing Reed for wrongful death on the same theory the Commonwealth pursued in the criminal case. They have also brought intentional and negligent infliction of emotional distress claims against Reed based specifically on her allegations regarding the police investigation and prosecution. The first participants in that investigation were members of the Canton Police Department. The Canton PD officer who received the 911 call concerning Mr. O'Keefe was Sergeant Sean Goode, who then was one of the first officers to respond to 34 Fairview Road, where Mr. O'Keefe was found. In fact, Goode testified at Reed's criminal trial. But remind me, chat, only the first trial, correct? I don't think he testified at both. Was it only the first one? Because remember, Malley called every single witness who responded to everything. And Hank Brennan was a lot more judicious and brief in the witnesses that he called. And I don't think Goode was called for trial 2, but you can remind me. I could be wrong. Just the one? Okay, thank you. Reed's subpoena to the town seeks disciplinary records relating to Sergeant Goode, including documents gathered as part of the Canton PD's investigation of Sergeant Goode's troubling communications with former state police trooper Michael Proctor, who was the lead detective on the O'Keefe investigation and arrested Reed. Indeed, Canton PD's investigation into Goode came in the aftermath of a jury finding Reed innocent of all charges relating to O'Keefe's death and the discovery of thousands of messages on Proctor's phone, including many to and from Goode. Goode and Proctor have been close friends for over a decade and were or are part of a small group chat in which they shared messages with each other about various topics. We're learning more and more. Nothing gets by us. We are eagle-eyed. Small group chat. There was a small group chat in which they shared messages with each other about various topics. I want to point out to you that the text messages that were exposed during trial number 1 of Karen Read, the persecution number 1 of Karen Read, which is the only trial that Michael Proctor took the stand at, by the way, the text messages that were revealed during that trial, during Proctor's testimony, were group messages between Proctor, aka Chip or Bear, those were his nicknames, and like all of his first grade buddies, right? So that was one group that we heard about, Chippy Bear and his childhood buddies. Then there was another group text message between Proctor, Buchanan, Tully, Fanning, and maybe some other MSP guys, in which he joked about no nudes so far, just going through his retarded client's phone, and how much he hates David Yannetti. And remember, Yuri Buchanan liked it, but he didn't really like it. And then Fanning disciplined him because he was on vacation with his 5 kids and he didn't really remember seeing it or anything like that. So it was Proctor and his MSP buddies. But as far as we know, Sergeant Sean Goode was not in any of those group text messages. And then we heard about some other group text messages between and among the McCabe's, the Alberts. That group text message, tell him the guy never went in the house. Proctor was not part of that group chat. But we didn't hear about any group messages, did we, between Proctor and Sean Goode from the Canton PD? Because remember, MSP, Canton PD. And so I don't recall Sergeant Goode being part of any of the group messages that we already know about from the trial, but you can correct me if I'm wrong. I also remember the group messages between Proctor, DeChico, Kakowski, Buchanan, in which Michael Proctor said, we can't get the whack job medical examiner or something like that to change her manner of death from undetermined to homicide. And then I think it was DeChico who said, rookie move, you should have let me and Jeff do it. Right? I don't remember if it was the same exact message, but he did refer to someone as a whack job. Karen Read one time, and also we thank the medical examiner another time because we used our context clues, and clearly he was talking about Irene Scorty Bello, the medical examiner, in my opinion. And he and Yuri Buchanan definitely tried to get her to change her manner of death determination on the death certificate of John O'Keefe a couple of times, right? And she wouldn't do it. Yes. But we don't know anything about this other small group chat with Goode, and who else was on there? They shared messages with each other about various topics. Did they share any nudes or intimate body parts of people not involved in the chat? Because we do know that that was found on Proctor's latest phone dump because the Norfolk DA's office told us that. Right? Whoever wants to make a FOIA request, you can find the actual form for a FOIA request right on Norfolk County's website if you choose to do so. It doesn't even have to, you don't even have to use the form. You can just put it in an email. The disciplinary history of one of the first officers on scene and his relationship with the lead detective on the case are directly relevant to the nature and reliability of the investigation, which is at the core of a number of plaintiffs' claims. As a result, those documents are well within the scope of discovery. The town's only other basis for opposing Reed's motion is that the Canton PD investigation of Sergeant Goode is ongoing. The town claims that this private employment matter allows it to disregard a legally issued subpoena and refuse to produce documents until the town decides that the investigation is completed, thereby controlling the timing of its own discovery obligations without regard to Reed's rights or the court's case schedule. The town does not cite a single case supporting this proposition or any other proposition. On the other hand, Reed's memorandum of law in support of her motion cites multiple cases that contradict the town's position. Reed will not reiterate her earlier explanation here. The town may not withhold these documents based on the status of its own internal investigation. Estimated completion date 2050. This is Norton cancellation. Hold on. Let me get off the camera for 1 second. I just got to respond to something. Give me 2 seconds. Talk amongst yourselves for a minute. Okay. Finally, the town's opposition contains a number of mischaracterizations of the parties' conversations and Reed's attempt to comply with Rule C. Hold on 1 second. Attached as Exhibit 1 are 2 email chains that reflect those attempts. Reed will not rehash them in full here. However, it is particularly disingenuous for the town to suggest, without any evidence whatsoever, that Reed would immediately provide documents related to the Goode investigation to the media. Yeah, they're not happy about that allegation. As the town knows, and as is reflected in Exhibit 1, Reed agreed to consider confidentiality restrictions on these documents while the investigation was pending to allay the town's concerns. See February 10th, 2026, 10:10 a.m. email. Despite initially indicating interest in this proposal, the town elected instead to ignore it, object to producing any documents under any circumstances, then suggest to the court that the offer never existed. In any event, there is no legal basis for the town's position. Courtney H. from Florida says, I need a shot of tequila. We have the exhibit, I think. I think we do. Hold on. XOXO. Respectfully submitted, Karen Reed by her attorneys, Aaron Rosenberg, David Seligson, etc. All the things and stuff. Alan Jackson. And everybody. Dated April 8th, which is yesterday, 2026. And that is the motion they spoke about during the conference. Exhibit 1. Okay, let's see. Let's see what we have. All right, let me move myself out of the way. We've got to read from the bottom up because even though it's in 2026, that is still how email works. So let's read from the bottom up. Wait, March 23rd. What's this? All right, so this will be the February 20th chain starting at February 2nd, January 30th. Okay, so let's start at January 30th. From the town attorney, David Karoyan, to Aaron Rosenberg, January 30, 2026. Hello, Attorney Rosenberg. I'm emailing to follow up with your previous correspondence with Attorney Kenny from my office and your request for additional records related to the subpoena issued to the town of Canton on or about July 22nd, 2025. I was hoping to set up a call for us to briefly discuss the matter. Do you have some time availability? Do you have some availability next Thursday or Friday afternoon for a conference call? XOXO, David Karoyan. It was January 30th, 2026. And then January 30th, 2026, Aaron Rosenberg responds and says, yes, I'm available Thursday at 2 p.m. or 4 p.m. and Friday anytime after 1. And then Monday, February 2nd, after no response, Aaron Rosenberg emails again and says, when are we speaking this week? And then on February 10th, Aaron Rosenberg writes to David Karoyan and Chris Kenny and says, David, Chris, thanks for the time last week. So I guess they did speak. As discussed, attached is a second, more discreet subpoena specifically relating to the investigation into Sergeant Goode, any misconduct and communications between Sergeant Goode and relevant individuals in our case. Please confirm that you accept service of this subpoena on behalf of the town of Canton and Canton Police Department. During our call last week, I explained that I had given the town the benefit of the doubt when Jamie told me that the town, including its council, did not possess further documents that would be responsive to requests like this. It sounds like the town may now possess at least some such documents, and they need to be produced. I understand that the town has some concern about disclosing documents relevant to an active investigation, and although that is not a valid objection to a properly issued subpoena in a civil case, I am willing, as I said on the phone, to consider limited confidentiality restrictions on these documents, which would be effective until the investigation is completed. If you would like to propose such restrictions, let me know. Otherwise, please produce responsive documents pursuant to the subpoena. XOXO, Aaron. He even said that he would put some restrictions on it. February 11th, Aaron Rosenberg writes, please confirm today that you accept service of the attached subpoena. Otherwise, we will serve the department directly. So here's what that does. If the attorney agrees to accept service of the subpoena, it prevents you having to send your process server to serve them formally. And it's just a courtesy that attorneys will grant to other attorneys to avoid the whole process server rigmarole. But apparently he had not responded until February 11th, when David Karoyan wrote back to Aaron Rosenberg, yes, as discussed, I accept service on behalf of the Canton PD. My office is coordinating with the department, and I will hopefully be able to follow up with you shortly regarding the subpoena. February 20th, from Aaron Rosenberg to David Karoyan. David, I assume the attached email/letter means that you are now refusing to provide any documents in response to the subpoena, even if we agree to confidentiality provisions. Despite our numerous attempts to confer, our offer to work with you to address your client's concerns, and your colleague's prior statement to me that the documents in question do not exist in the department's or town's possession, custody, or control, which your letter does not assert. Please confirm that I understand your response correctly, and if so, please let me know when you're available on Monday to confer pursuant to Rule 9C in advance of an immediate motion to compel, as Judge Gilday has urged us to do in this case. Thanks, Aaron. That's exhibit. Then there's another chain that goes to starting on February 20th. So this must be the attached email. This is from David Karoyan, February 20th to Aaron Rosenberg. Attorney Rosenberg, enclosed, please find the Canton Police Department's objections to the subpoena regarding the above referenced matter. A physical copy has been mailed to your attention as well. That itself is not attached. And then on March 23rd, Aaron Rosenberg writes back to David Karoyan, attached is defendant Karen Reed's motion to compel the town of Canton to produce documents pursuant to non-party subpoena and a memorandum of law in support. I understand from our previous phone conversations and email exchanges that you are not willing to produce any documents in response to the relevant subpoena. If I'm incorrect or you believe further conversation pursuant to Superior Rule 9C would be productive, please let me know and I'd be happy to schedule a time with you. And that is where it ended. And that is why they had to make this motion. Thoughts, questions, comments, concerns. Oh, thank you, Siobhan. So I love your Irish eyes. Thank you for your 10 for just complimenting me. Thanks, ARW, for becoming a member. And Bridget says, Kevin, Albert, and Sergeant Goode, maybe. I don't know. I don't know. They're looking for, I mean, Kevin Albert and Sergeant Goode both worked together at the Canton PD. It would not be uncommon for them to have communications, right? At all. I mean, they worked together, right? Whether or not they had any conversations about Karen Reed, we don't know. But I don't I'm sure they would not deny that there would be communications between them, right? We just don't know what they have to do with. Thank you, Bridget, for your 5. And then good gone bad, says Bridget. Thanks again for your super chats. Michael says, I can see why the judge was pissed off. Well, that girl T, what I did was listen to the Zoom hearing and I reported on it as it was going. It was very short. It was boring. And I couldn't stream it because it was not allowed to be streamed. And so I told everyone what happened, but I will recap for you now. The judge was not happy because no depositions have been held yet. The first deposition will be held next Tuesday, and that is a deposition that was noticed by Karen Reed. Damon Seligson has noticed 11 depositions, but none of them have been held yet. Not Damon Seligson. Mark Diller, plaintiff's attorney, has not conducted any depositions at all, but he has sent out 11 notices of depositions for certain people. Karen Reed's team, as you know, has noticed something like 40 depositions and told us which ones they intend to conduct first. The first one's going to be held on Tuesday. The judge wasn't happy. He's like, well, I guess y'all want to waste your summer doing depositions all summer. And then Diller also told us that they sent a subpoena to the Norfolk DA's office for records in the Aiden Carney case, that they think that somehow is going to be related to their wrongful death action against Karen Reed, the Waterfall, and CF McCarthy's. And when it was suggested that they come back May 7th for another status conference, Aaron Rosenberg said, oh, we're doing a deposition that day of one of the troopers. And the judge said, which one? And he said, Brian Tully. And the judge said, we can put the conference on for 3 p.m. because you should be done by then. 5 hours is plenty of time. And Aaron Rosenberg said, yeah, no, I don't think so. I don't think we're going to be done with Tully by 3. But the judge said, I'm going to put the conference on for 3. Maybe that will give you some incentive to finish that deposition in 5 hours. I think Tully's going to be deposed for days. For days. Canton loves to keep it secrets, but time to spill, says Lola the good dog. That's what I'm saying. Did you guys hear? All right. So what the other thing I was going to tell you about. So this motion will be heard on April 28th, 3 p.m. It's going to take way longer than that. Is David Yannetti's new case. Did you guys hear about this? I'm going to tell you about it. Here it is. I'm going to read you the article from Boston 25 News. Let's take this down. Let's put this up. And this is being reported by Boston 25 just today, April 9th, hot off the press at 11:30 a.m. Eastern, a couple of hours ago. High-powered Karen Reed attorney to represent Boston police officer charged with manslaughter. Oh, let's watch the video. Now playing above. Okay, I got to suffer through the... Nope. I hate when they do that. Above where? This ad will end in 10 seconds. Okay. I'm going to suffer through the ad for you.
A lawyer who represented Karen Reed will take on the case of a
Ted
Boston
Daniel.
police officer accused.
Okay, that is not me. That is them with really, really bad video feed. Let me take it back.
Officer accused of manslaughter in
all right, here we go. Ted Daniel reporting from Boston 25.
Breaking news. A lawyer who represented Karen Reed will take on the case of a Boston police officer accused of manslaughter in a deadly carjacking in Roxbury last month. Attorney David Yannetti will be retained for Officer Nicholas O'Malley. The firm says O'Malley was falsely accused of manslaughter because he performed his duty and defended his fellow officers. Stevenson King Jr., a carjacking suspect, was shot and killed. Prosecutors say body camera footage shows officers were not in danger. The footage has not been released. O'Malley alleges King was going to run his partner over. He's on leave and pled not guilty to manslaughter. And a well-known civil rights attorney is representing the family of Stevenson King Jr. Ben Crump says his job is to get justice for the family. Crump is holding a news conference in the next hour to demand transparency and accountability. Boston 25 is going to be there and covering the developments. We will bring those to you.
Huh.
Of the 1 in 10 Massachusetts residents who have unclaimed money, 591
order today and get an extra.
Stop. Wait, let's go back to that article. And I wonder, did they have that? Did Ben Crump have that press conference today? I know it's the worst website. And they wonder why, Magnolia Gypsy, that nobody, I know. What I usually do is put it in reader mode. You can get an extension for your browser to do reader mode, and it takes away all of these pop-ups and everything. He also put out a press release, David Yannetti did. So let's just see if there's anything else here in this article. Usually their articles just parrot. Just parrot what Ted Daniel said. But Officer Nicholas O'Malley is a 33-year-old Westfield State graduate and native of Randolph. He was arraigned last month on a charge of manslaughter. Boston Police Department narrative detailing the March 11th, 2026 incident revealed that there was probable cause to believe O'Malley committed voluntary manslaughter by intentionally firing at 39-year-old Stevenson King, causing his death, and doing so without acting in reasonable self-defense. It's going to be exciting to see David Yannetti in court again, right? Is it just me? Officers responding to 1590 Tremont Street for a reported carjacking on the evening of March 11th spoke with a woman who said she had been seated in the passenger seat of her running vehicle when a male suspect, later identified as King, had assaulted her and dragged her out of the car before fleeing in it. 2 officers later located the stolen vehicle, parked at 10 Linwood Square in Roxbury. Body-worn camera footage captured the officers approaching the vehicle with their firearms drawn and shouting commands at King, who was reclined in the seat, the police report stated. According to investigators, O'Malley approached the driver's window while the other positioned himself behind the vehicle. O'Malley then allegedly drew a taser and yelled, "Bro, I'm gonna effing shoot you." Authorities say King then shifted the car into reverse and back toward the officer behind the vehicle, striking a cruiser before moving forward and backward again in an attempt to escape. During the final forward movement, O'Malley fired his gun at least 3 times, striking King, according to police. King's vehicle then accelerated, crashed into a stone wall, and came to a stop. Officers removed King and performed CPR until EMS transported him to the hospital, where he was pronounced dead at 10:24 p.m. An autopsy found that King had been struck 3 times with 2 bullets recovered from his torso. A 3rd projectile was found inside the car's passenger side seat. Investigators say no weapon was found on King or inside the vehicle. After the shooting, O'Malley allegedly radioed that King had tried to run us over. But investigators say body-worn camera video contradicts that claim, showing that neither officer was in the vehicle's path when shots were fired. During an interview, O'Malley allegedly claimed he believed his partner was going to be crushed by the vehicle. However, investigators concluded that the belief was not reasonable based on the video and eyewitness accounts. Yannetti said Thursday that the Suffolk County, that's today, that the Suffolk County DA's decision to charge Officer O'Malley with a crime is an example of Monday morning quarterbacking and does not acknowledge the split-second decisions officers must make every day in life-threatening situations. Well, for that, let's go to David Yannetti's press release. This article goes on to say, King's family has retained high-profile civil rights attorney Benjamin Crump, whose previous clients include the families of George Floyd and Breonna Taylor. Stevenson King Jr. should be alive today. His family is now forced to carry the pain of a loss that should never have happened, Attorney Ben Crump said in a statement Monday. His family deserves the full truth, real accountability, and justice that is not delayed or denied. We will not stop fighting until they get it. Let us now move on to David Yannetti's press release. From earlier today. which is, where did we go? Let's see. Here it is. 2 for immediate release. David Yannetti also started a new, I guess a partner joined him. He now has a firm, and his new firm is called Yannetti Johnson, PLLC. For immediate release, dated today, April 9th, 2026. Contact David Yannetti, defense attorney for Nicholas O'Malley. To all media outlets from David Yannetti, Esquire, and Christina Pujals Ronan, Esquire. The defense regarding the defense of Boston police officer Nicholas O'Malley, dated today, April 9th, 2026. Yannetti Johnson, PLLC, is honored to announce that we have been retained to represent Boston police officer Nicholas O'Malley, a good man who finds himself falsely accused of manslaughter because he performed his sworn duty and defended his fellow officers when confronted by a dangerous criminal with an established history of violence and felonies. Attorney David Yannetti recently spent nearly 4 years zealously fighting a district attorney's office that protected bad police officers while prosecuting an innocent woman. An injustice could have occurred, but thankfully a jury saw the truth and acquitted her. Oops. Attorney Yannetti and attorney Christina Pujals Ronan now stand prepared to zealously fight another district attorney's office that is apparently choosing to protect criminals while prosecuting good police officers. We look forward to preventing another injustice in this case as well. That's interesting. He's now taking the cop side. I have known nothing about this case other than what I literally just cold read to you from the Boston, whatever that was, Boston 25 article. Officer Nicholas O'Malley has always maintained a stellar record as a sworn Boston police officer. He is an exemplary family man, a husband, and a father to young children. He chose to become a police officer for all the right reasons, to protect and serve the public and to do the right thing when called upon. Every officer who puts on the uniform realizes the risks of the job and willingly accepts them for the greater good. The decision to charge Officer O'Malley with a crime rather than to acknowledge that his actions occurred during a life or death situation sends a clear message to our police officers that this district attorney's office does not care about their lives or safety. Instead, while sitting in comfort at their desks, this district attorney's office is demonstrating that it prefers to Monday morning quarterback and second guess the split-second decisions of police officers and punish them for trying to protect the public from violent menaces. We will not rest until Officer O'Malley is rightfully acquitted. Well, now I'm going to fall down the rabbit hole on this one, huh? Oh, please. I'm going to. If you didn't watch my show from earlier today, we went over the entire guilty plea of Rex Heuermann, which is a very personal story to me, having lived on Long Island for my entire life and having dealt with body parts washing up on our Long Island beaches since at least 1996. Pujols. Pujols? Thank you. Thank you, Kelly. It's like every other Massachusetts name and town that I can't pronounce. Her name is Attorney Pujols. Thank you very much. Thank you very much, Kelly. So for those of you that did not watch the Rex Heuermann show this morning, please go watch it. For those of you who did watch it, tell me how you liked it. All right, well, let's take a look now. We're going to take a look now at the 2 weeks ago. Well, let's start 3 weeks ago when somebody else was representing Nicholas O'Malley. Let's take a look at 3 weeks ago when this incident first occurred, and let's watch some initial coverage on Police Officer Nicholas O'Malley. This was from Channel 5 in Boston. Wait. Why are you buffering? Yo. That's weird.
The country. The very freedoms that we all enjoy, you and us together, are because of these men and women behind me. And they commit.
Not preference. Ever been.
Back.
Client's perception is what matters here, and he stands by his actions. I think at the end of this case, he's going to walk away as an innocent man.
Mr. Anderson, the DA said that they arrested your client to not show special treatment in this case. What's your response to that?
So I guess David Yannetti did not represent him at the time, or this was his union attorney. I'm not sure. But this was from 3 weeks ago. The date that this was posted is March 19th, 2026.
I've been involved in probably 100 or more police shootings. This is the first one anyone's ever been arrested. This is not preferential treatment. This is election year tactics.
What do you think about the fact that body-worn footage will be released by the DA or Boston Police Department?
That it will not be released?
That's what we just heard.
I favor that. I mean, at some point, we need transparency. The police need transparency that the community can trust them. But while this is under investigation, I think it should be kept secret and let the process play out. And at some point, we'll have transparency.
Folks, one of the most important things that you need to hear from the rank and file officers that are with us and the family that was here with the officer is these men and women come to work every day to keep Boston the safest city in the country. The very freedoms that we all enjoy, you and us together, are because of these men and women behind me. And they come in every night to protect the citizens of Boston. And in a split second, they have to make a determination on what to do. We heard the DA's representative upstairs talk about the officer used verbal commands, utilized his taser, then went up the force continuum. What we're looking for, folks, is compliance. I don't hear anybody ever talking about when do we get back to the way years used to be. When a law enforcement officer comes on scene and they're giving you verbal commands and they're giving you instructions, it's a two-way street. Compliance is a must. Now, I'm not there to pass blame to the individual. It is a complete tragedy that we're here today even talking about this. It really is. But we have an individual that's no stranger to the criminal justice system. Again, I'm talking and I'm giving you facts from the DA themselves.
This Boston accent is everything to me right now. All right. Well, I'm going to let him keep talking. I'm not sure who he is. He may be the union spokesperson.
An individual that's been arrested multiple times. It's an individual that knows what it is to follow verbal commands. That's a must out on the street. When an officer in uniform is asking you to see your hands, to shut the car off, to put it in park, please help them. No officer ever wants to take a life, ever wants to discharge their firearm. But we carry that piece of equipment to keep you and your family safe, and we do a very good damn job at it. The facts show it. That's why we're the safest city in America.
Thank you, Mark.
So we're here very strongly to tell you that we back our officer.
Is Boston the safest city in America? Where did he get those statistics from? Thank you, Mark, for thanking me and for your 5.
And at the end of the day, Attorney Anderson is right. The facts are going to come out. That officer was in fear of his partner. It's very easy on Monday morning to take a look at a body camera and try to determine what an officer felt from your point of view. No one here knows how it is to be a man or woman in uniform. None of you know what it is to have your life, your partner's life, or some other innocent victim, possibly their life in your hands, and have to make that determination in a split second. Very easy, again, on Monday morning to take a look at a body camera and say, an officer said this, his camera shows this, we disagree with that officer and how he or she felt. Yeah, that's easy. Try being the officer in 2 seconds to process all of that information, to give it verbal commands, to pull a taser, to go to his next piece of equipment, and make the right decision all the time. I guarantee you, you have no idea how that officer felt. We do. We've made that determination many, many times, and unfortunately, we're here today with a tragedy. Yes.
Larry, how are the officers feeling now about doing their jobs, having seen a fellow officer get arrested so quickly?
I probably can't answer you correctly for the 50-odd officers that are standing behind me, but why wouldn't we second guess our job? How can we not go to work knowing that we gave verbal commands, we pulled a taser, we went up to the use of force continuum? Our own Boston Police Commissioner is quoted in the paper saying that they gave verbal commands, the individual backed his car up multiple times, crashing into the police car and putting the officers in danger. That's our own Boston Police Commissioner. Why wouldn't we be outraged? Why wouldn't these men and women think a second thought now while they're out there protecting citizens? Every man and woman here that's a parent or a father or a relative has the right to go home at the end of the day the way they came to work, happy and healthy. And we do the very good job at that. Yes, sir.
Larry, can you just talk about the perception? The report says the car was going back and forth, trying to free itself from the curb and the cruiser. What kind of perception is that for an officer? Like, does he have to necessarily be in the path like they say he wasn't? I mean, just the fact the car's jostling around.
I'll be careful not to tarnish the case as it moves forward. Will I answer that? But every individual officer is different, and every scenario is different. Sometimes the car is backing up, and he's backing up down Dudley Street, and you're 25 feet away. You have plenty of time to move out of the way. Other times you don't. Sometimes the car is moving faster. Sometimes you're stuck in between parked vehicles.
Wait, so he's saying with 25 feet, you have plenty of time to move away from a vehicle backing up. So let's just, I mean, everything always goes back to Karen Reed, right? How many feet did they finally land on? Did they finally allege that Karen Reed backed up? How many feet? 60 feet at 24.2 miles an hour? And he just said in 25 feet, you would have plenty of time as an officer, as a Boston police officer, to jump out of the way of a moving vehicle, right? He just said it. I mean, he said it. Hold on. I don't know what the video shows because I don't think they've released the body cam footage, right?
I'll be careful not to tarnish the case as it moves forward. Will I answer that? But every individual officer is different, and every scenario is different. Sometimes the car is backing up, and he's backing up down Dudley Street, and you're 25 feet away. You have plenty of time to move out of the way.
25 feet away, you would have plenty of time to move away. I mean, he just said it. I'm just saying. So what's the difference between Officer Noonan shooting Kelsey Fitzsimmons, right? And this instant, well, body cam for one, right? I don't have any opinions on this case because this is literally with you right now, the first time I'm even looking at this. I remember you guys telling me about this happening, but we were neck deep in other things, and I have not looked at anything until right now. So I have zero opinion on it. But body cam.
Other times you don't. Sometimes the car is moving faster. Sometimes you're stuck in between parked vehicles. Every situation is different, so I can't answer not seeing the body camera and not being on scene that night what those officers were feeling and where they were situated, and how much danger they were in.
But is perception different for each officer?
But perception is different for each officer is where I was going. And what might terrify me, maybe this officer handles it differently. That's where I went in on the Monday morning quarterbacking. It's very easy, folks, to take a look at a body camera and try to determine that, you know what? I think that guy was standing far enough away from the car that maybe he shouldn't have thought his life was in fear. I'm here to stress to you, I've done this job. I've been a policeman for 31 years. My perception and my life being in fear is much different than the district attorney who's sitting behind a desk Monday morning watching a video.
Larry, are you claiming this is a political maneuver by Kevin Hayden?
I'm not going to take any shots at the district attorney. I'm not going to pretend that this is political in any way. I had a brief moment with the DA in the hallway. I expressed what I'm expressing to you here. It makes the job of these men and women so much more difficult to be dragged in here a few days after an incident happened when clearly we all read the newspaper and the Boston Police Department can't adhere to the regular post-commission requirements in 90 days, 180 days, 360 days, but yet they could drag our officer in here a few days later because somebody's opinion of their body camera says they should have acted differently. Normally, you don't hear me talk like this. Many of you I've had interviews with before. Is this an outrage? Absolutely it is. Should our men and women feel?
He's outraged. He is definitely outraged. And I don't know the answer to this, Lola. Lola wants to know. And if you're in the area and you know, She says, Lola says, aren't cops usually represented by union lawyers? Thank you for your super chat. I don't know the answer to that. I think he originally was. I know that David Yannetti is not representing him as a union lawyer. I imagine he's a private attorney for him. So if anybody knows the nuance there, I don't and can't possibly know everything. So if you do know the answer to that, and you really know the answer to that, feel free to comment in the chat.
Outraged and discouraged from doing their job like they do, yeah, unfortunately, that's how we're feeling.
So do you think maybe they shouldn't shoot at this point?
I'll grab everybody, no worry.
I understand when Inco was trying to talk about this guy, he was out in 4 different open cases, some involved guns. That was kind of dismissed by the judge, but does that play into it too, the perception?
I don't know that the officers knew that about the individual. And listen, if somebody's been arrested 19 times and they're out on bail and they're driving around the street and they're confronted by a law enforcement officer in full uniform and they're given verbal commands, please comply with those verbal commands. We're not judging anybody if we have information on them or not. We're judging them for the crime or the scene that's happened at that point in time. And if the officer's telling you to shut off the car, please shut off the car. If they're telling you to show them your hands, show them your hands.
I mean,
that police officer
really good
is in
advice.
fear.
All really good advice. Really good advice. Please comply.
Of their life just as much as the person that's being stopped or questioned might be in fear of the officer. But again, it's about compliance. It's a two-way street. Help us, help you. Help us keep everybody safe, the men and women in uniform and the people that we're dealing with. Yes, miss.
What do you think of the ADA's comments and statements in court that firing his weapon endangered the other officer on scene?
That's part of my Monday morning quarterbacking, and I'm kind of irritated with it, as you could see. For the assistant district attorney to try to convince you or anybody else about how that officer felt, what that officer saw, when his body camera in his chest is what they're looking at, is preposterous to me. They can't possibly know how that police officer felt. And just because the camera shows an officer on the other side of the car with the totality of the circumstances that were taking place does not mean that the other officer actually had him in his vision. So we're in total disagreement with that, and it's upsetting for somebody else that was not there to try to add their opinion in 2 days, 3 days, 4 days later.
Maybe this is a misunderstanding, but the report is written by a police officer that says that there was cause.
Okay, this is not his attorney at the time. This, I believe, is the union spokesperson. People are saying, like, argue it in court. I think this is the union guy, right? He's passionate. And he's sticking up for his police officers. I like that.
How do you respond to that? That's a police officer, not a... I understand the Monday morning quarterbacking from the DA's office perhaps, but is this police officer? How do you characterize that?
Thank you. The union rep. Thank you. The union guy.
Those police officers came to that conclusion and wrote that report based upon the investigation of the district attorney's office that night on scene. And it is part of the protocol and the process for the police officers to document it in the report. But I guarantee you that's the opinion of the district attorney, as you heard upstairs.
This is the department that's worked hard at community policing.
I'm sorry.
This is the department that's worked hard at community policing. Yes. Are you concerned, a man who died in this situation, are you concerned about the relationship between Foster Police and the community based on this incident?
I'm not concerned about that at all. Listen, we are the poster child for community policing across the country. Let's not forget that President Obama himself said that you want to talk about community policing, look no further than the Boston Police Department. We're the best in the country, folks. There's a reason why we are the safest city in America, and it's because of these men and women and how they interact on the street. We talk to the general public. We're out there every day. The union officials that are with me, we're out there conversing with the general public. They love our men and women. I don't think it's going to hinder us at all. We're good at what we do.
Is there a message after seeing your officer in handcuffs in the courtroom today? Is there a message to the other officers in the Boston Police Department? Don't shoot.
I haven't heard that message, and that message I don't think is what's going to come forth. Unfortunately, there are instances where police officers are faced with life and death situations, their own or that of an innocent bystander, and that is why they carry that weapon.
Can you confirm how long
it's
been since a Boston police officer was arrested and charged with manslaughter for an officer involved shooting? And what does it say about this?
Excuse me, my apologies. I don't know the exact date, but approximately 30 years is the last memory that I have that a police officer has been arrested and charged with such a crime.
It's been 30 years. Wow.
Were you able to talk to him, or is it?
His family was here today with us. They were in the courthouse. They've since left. That's a difficult question for me to answer. I can't pretend to know how Officer O'Malley feels. Looking at him, I'm sure he's depleted, and I'm sure he's second-guessing the entire incident that happened. But he's a strong individual. He has an impeccable young career that he's involved in. It's an unblemished career, and he acted courageously for what he testified to, as you heard. He did not know where his partner was. He was in fear of his partner's life. He gave multiple verbal commands. He tried to utilize his taser, but could not because of the actions of the individual. And unfortunately, we're standing here today with a tragedy and a loss of life.
Yannetti, thanks, Emma. Louise Critchlow. Yannetti represents the officer, Nicholas O'Malley. He's the cop's lawyer. I mean, I don't know anything about this case. Like I said, I'm just hearing about this now. I don't know anything about it. We've covered a lot of cases involving bad cops, right? And I don't know the circumstances here at all, but wouldn't it be nice to cover a case of a good cop? I'm just saying, if it turns out that this was a good shoot and a justified shooting, wouldn't it be nice? Because not all police are bad. And that's why we don't allow people to just generally trash police and law enforcement in the chat, because I come from a family of law enforcement. Many of you come from families of law enforcement, and nobody hates a bad cop more than a good cop. Okay. And I do back the blue 100%, except for when they're corrupt. Okay. And so it would be nice if it turns out to be the case, which I don't know. But either way, if you are interested in covering with me the case of Officer Nicholas O'Malley, please let me know. And it's not just because King David Yannetti is now representing him, but many of you brought this to my attention today, okay? Because there are way more good cops than bad cops. There are way more good priests than bad priests. Same goes for doctors, lawyers, all professionals that people hate. Teachers, right? There's the good and the bad. And sometimes it feels like, because of all the cases that we cover, it feels like the bad is always outweighing the good. And it feels like there are people that are being persecuted that shouldn't be. And we together, because I choose my cases to cover so carefully, that cases that have legal nuance and, cases in which two things can be true that seem diametrically opposed. Lindsay Clancy may have murdered her children, but she also may have been completely insane and over-medicated because of her postpartum psychosis. Both things can be true. So let me know if this is something that you'd be interested in covering. I see a lot of yeses. Okay. Let's play this out. About less than 2 minutes left.
Is it because the window was up?
The window was partially cracked at one point when the officer was attempting to utilize the taser, from what I understand, upstairs from the district attorney.
And that's why he couldn't use the taser, because the window was largely up.
I'm going by what the DA said. I have to be careful in the way I answer.
Are you saddened by the arrest today or outraged by the arrest?
Both. We're outraged at the way the arrest took place. You have an individual, again, with an impeccable record that volunteered to go give testimony at Fitted at the homicide division. He could have very easily volunteered to come in here and submit himself to the accusations at hand. And why are we sad on the other side? We're sad because the assistant district attorney and whomever else is involved in this investigation is jumping to conclusions, is scapegoating and utilizing this officer for whatever reason. I'm not calling it political, but to watch the department for 3 decades take their time and do thorough, lengthy investigations, and then in this case, all of a sudden, you have a couple of city councilors that want to look at the body camera and they arrest the police officer. I remember the days of Police Commissioner Bill Evans would invite city councilors upstairs, sit down and view the body camera. Total transparency. Let me say that. The union is not about not being transparent. We're about transparency, but we're about fundamental fairness. Our police officer deserves the same consideration and the same rights that any other citizen would expect and deserves. Plain and simple.
Can you speak about just the danger of shooting at a moving vehicle?
Thank you very much, Kimberly. Kimberly says, yes, let's cover this one, Melanie, and throws in a $50 super chat. Thank you so very much for your generosity. Thank you so very much. That is very, very, very sweet of you. I appreciate you so much, more than you know. Robin J says it might be political. Listen, I don't know anything about the person who was shot. I don't know their race. I don't know their political views. I don't know anything about it. If we can keep this to the facts, it would be an interesting case to cover. Michael says it would be interesting to see the police IA report to see what it says. Well, you know what's so interesting? They've had 6 months on Sergeant Sean Goode. That IA report is not out yet. This only happened. What was the date of this event? This was in March. This was this month. Well, no, we're in April now. So March 11th. It's not even 30 days old. You can bet the IA report is not out yet. Remember how quickly the officers were cleared in the Justin Root shooting? Remember how quickly they were cleared? Remember how quickly Matthew Farwell was cleared? He was never even investigated for the murder of Sandra Birchmore and still won't be. And how quickly, it seems from what I'm reading here on the side as I'm talking to you, how quickly this officer was charged with voluntary manslaughter without acting in reasonable self-defense is what they're saying. And this article is from April today. This article is from today. And Officer Malley, 33 years old, apparently has a stellar record according to the union rep. I want to let this play out. When you speak to the danger of shooting
Unfortunately,
someone,
I don't think that I can talk about that given this case because that's going to come up in the trial in this very instance. I apologize.
Oh, look, my own thing popped up. There's a 52-minute hearing on it, which we can cover another day if you want to do a deep dive into it. It's only 30 days old, this case. So now that David Yannetti's involved, it might get like attention, and Court TV and Law and Crime might want to stream the hearings and stuff. So that would be good. Let me know what you think. Let me just see if I can find a short piece. All right, here's a short piece that gives us, it's Fox. They don't like me using their stuff. They'll strike me. Hold on. Let's try this. Police officer. This is CBS Boston. Just a shorter piece with a little more detail. That was mostly the union rep talking. And this was breaking news 2 weeks ago, March 20th of 2026. So I guess that's when he was charged. March 20th. The incident was on March 11th. So it took them only 9 days to charge him. Okay.
Boston police officer accused of shooting and killing a suspect walked out of court surrounded by fellow officers who blocked camera crews from recording his exit. The police union says the officer's arrest is unprecedented and outrageous. But as Aaron Parsegian reports tonight, the district attorney says he never should have pulled the trigger.
There were more than 40 Boston police officers inside the courtroom to support Officer O'Malley as he was formally charged with manslaughter in connection to a shooting the DA says was not justified. But O'Malley's...
How many officers showed up to support John O'Keefe? 0. Maybe 1 or 2 of his friends. On the O'Keefe, sat on the O'Keefe side. Hold on. One of them was kicked out of court for allegedly assaulting Karen in the hallway. Remember? Carl Dougal, remember? Tonight, the district attorney says, hold on.
He never should have pulled the trigger.
There were more than 40 Boston police officers inside the courtroom to support Officer O'Malley as he was formally charged with manslaughter in connection to a shooting the DA says was not justified. But O'Malley's attorney and the Boston Police Union call his arrest outrageous. Blocked off by fellow Boston police officers, Nicholas O'Malley left Roxbury District Court charged with manslaughter.
Plea of not guilty entered. Defendant has been arraigned, Your Honor.
The 33-year-old arrested Thursday morning, 8 days after this deadly police shooting in Linwood Square. O'Malley's charged with shooting and killing Stevenson King, who the district attorney says that night committed an unarmed robbery. was in the front seat of a stolen car when he was approached by O'Malley and another Boston police officer.
After Mr. King's failure to heed repeated commands by the officers, he attempted to flee in the car. Officer O'Malley fired through the driver's side of the car.
So this is the district attorney of Suffolk County. This is the district attorney, Kevin Hayden, who decided to bring charges against Officer O'Malley. I'm going to take that back a second. But again, officers don't know whether or not the guy is armed, right? He was carjacking a woman. I think he assaulted the woman before carjacking her. I think I read that in the article, but I could be conflating my cases now. So hang on.
Stolen car when he was approached by O'Malley and another Boston police officer.
After Mr. King's failure to heed repeated commands by the officers, he attempted to flee in the car. Officer O'Malley fired through the driver's side of the car, striking Mr. King 3 times.
Well, O'Malley told investigators he thought his partner was going to be crushed. Suffolk County District Attorney Kevin Hayden says their review of body-worn camera shows that belief was not reasonable.
The facts are going to come out. That officer was in fear of his partner. It's very easy on Monday morning to take a look at a body.
Okay, so this now answers my question. The union rep, his name is Larry Calderon. Larry Calderon, Boston Police Patrolmen's Association. That's the guy we heard talking before with the, I would say, denim-colored quarter zip sweatshirt.
Camera and try to determine what an officer felt.
Police union leaders outraged over O'Malley's arrest, one his attorney calls unprecedented.
Grab him off the street, they arrest him, they book him to embarrass him, to put this show on for all of you.
Law enforcement expert Todd McGee says in some ways it is unprecedented.
This was interesting to see that this process played its way out.
But adds there is much more discovery needed through the legal process.
You'll hear a term called the totality of the circumstances. That does not give the police officer the ability to have 20/20 hindsight. That is the officer in real time making a decision. This is what is going to be part of the assessment.
That was Todd McGee. I love Todd McGee. I just recognize his voice and I can see him, and I love Todd McGee. I think he's the voice of reason in so many of these cases, and I love him so much. I want to give him more FaceTime. Let's listen again to Todd McGee.
Term called the totality of
more discovery needed through the legal process.
You'll hear a term called the totality of the circumstances. That does not give the police officer the ability to have 20/20 hindsight. That is the officer in real time making a decision. This is what is going to be part of the assessment by the prosecutors, by the defense attorneys.
One thing that won't come out as this case likely goes in front of a grand jury is the body camera video. The DA says they will not be publicly releasing that despite pressure to do so. In Roxbury, Aaron Parsegian, WBZ News.
All right, so they're not going to release the body cam footage, and maybe they should keep it close to the vest right now, yeah? Cherie from Australia says O'Malley's GoFundMe has reached $500,000 already. Wow. I mean, I love Todd McGee too. Thank you. Pammers says, I'm conflicted watching all the police officers on camera now versus all the cops showing up at Kelsey's trial last week. That seemed like intimidation. Did, right? Thanks for being here for 6 months, Pammers. Diane says, the AI Oracle says that they are not required to use a union attorney. Well, Ken Anderson was the original attorney. Bye-bye, Ken Anderson. Hello, David Yannetti. So I guess they can choose whatever attorney they want and the union will pay. I'm really not sure. So I don't want to give you wrong information. And AI may not always be right. So I don't know. But I will try to find out the answer for you guys. Thank you again, Kimberly, for your very generous 50. Jody says, do we know what courthouse this will take place and when? I could be a cupcake in the gallery. Still planning on being there for Sandra's trial. Sandra's is in federal court. This one right now is in district court. They just said which district court it was. Roxbury. And so I imagine that once he is indicted, if it's going to a grand jury and he is indicted, that it will transfer over to Superior Court based on the charges. So I do not know right now when or anything, because literally just looked at it 5 minutes ago. Thank you for your 5. Chris West says, I back the blue and support officers. I'm glad I found you. Thank you. Thank you very much for your 5. And thank you for finding me. And I'm very happy that you found me too. Not to compare this to any other case, but I did handle the Daniel Penny case. And I was on the side of Daniel Penny. And we did listen to that acquittal together because cameras were not allowed in the courtroom. As I recall, it was New York. We had to listen to and read live real-time reporting. And the Daniel Penny case, in my opinion, was very, very tragic case. Very tragic. So thank you for bringing that to my attention. I'll allow it. Wants to dive in. She said she wanted to dive in. Many of you sent it to me before this Karen Reed stream was already already planned or scheduled. And so we dove right in. And I think we're going to have to cover it. We'll take it from here, right? We will take it from here because we ain't got no quit. And it would be nice, depending on the facts and what we believe to be the facts, to support a good cop for a change, because we see so many bad ones. Right. Tarot Queen Bo says, is O'Malley the scapegoat to make Massachusetts feel like one cop in particular is being held accountable? I guess we'll see, right? Suffolk County DA. What are you guys' thoughts on the Suffolk County DA? I don't know anything about this guy at all. But Witterbird says, I'm invested. Who else? Thank you, Melanie. Oh, sorry if you didn't get an alert. I scheduled this literally 45 minutes before I went live with it because I didn't know if we were going to be able to watch the hearing, and we were not able to watch it live, actually. So I just listened to it and then told you what happened. It was very, very short, but somebody said Trial Channel does have it up. So if you guys want to go watch it, Trial Channel can take the strike if they get in trouble for broadcasting it. It was literally 11 minutes long. Go on over to the Trial Channel, give them a like and a sub. And they did post it over there on their channel, even though I was forbidden from live streaming it. Maybe they could record it after the fact. Maybe they had permission from the court to record it after the fact, but I'm not taking any chances over here. Because what would you guys do if I wasn't here anymore on YouTube? Wouldn't you be so lonely? Wouldn't you be? Lynn says, union lawyer may not feel qualified to handle manslaughter charge. Possibly union hired Yannetti or individual can seek own legal counsel. I don't know. I don't know the answer, but I will try and find out for you. Thank you, Scott Messerschmidt, for reminding everyone to please hit the like button to push the video out. Helps the algorithm. The algorithm of YouTube is changing every day, and they're trying to push you towards shorts instead of long form content like this, where I can keep you entertained for 4, 5, 6, 7 hours at a time. Tell me this. It was bad enough on your vacation, said Nicole, but I get it. I did go live twice on my vacation, right? I did. No camera because of all of the power that it took. It would be glitchy, and I get mad when the quality is bad. So, tell me, Annie said it was sad if you were gone. Oh, you're so sweet. Tell me what you're watching. How many of you were invested in the Dr. Gerhard Koenig trial? Tell me what you think about the verdict. If he was found guilty of attempted manslaughter in Honolulu. Tell me if you are watching the very sad case of the little Athena Strand, the 7-year-old. And tell me, oh, hi, Sco Buffs. I was just there. I was just in Boulder. See you, Buffs mom. Is anybody following the trial of the Jackson State University football player that was killed by his roommate in Mississippi? Because I can only find bits and pieces of the coverage, and I would like to cover that. And it's hard for me to jump into the Athena Strand trial because we're already 3 days behind. I can't handle it either, to be honest. I can't. Yeah, no, it's a FedEx driver. His name is Tanner Horner. He's autistic, so he doesn't think he should get the death penalty. It's in Texas. He was a FedEx driver who kidnapped a 7-year-old beautiful little girl after delivering a Christmas present to her house. The all-you-can-be Barbie set, ironically. Kidnapped her, threw her in her FedEx truck, and then took her life. There's interior vehicle footage from the FedEx truck of everything that happened after that. I just can't handle it. And he claims that he backed into her, and then she was going to tell. He didn't know what to do. He freaked out. He threw her in the truck. The video apparently shows her perfectly fine, but apparently he said that she threatened to tell her dad that he hit her with the truck, so he panicked and he took her life, and then he dumped her body, and then she was found a couple of days later, and now he's on trial and he's facing the death penalty in Texas. And it just gives me a stomach ache just even telling you about it. And he says, because I'm on the spectrum or I have a TBI, I shouldn't get the death penalty. And so that's what that is happening. I mean, that's that trial. And I don't know if I can't stomach it. It gives me pains just to talk about it. It seems like now that Law and Crime and Court TV are owned by the same owner, that they're covering all the same trials. Why don't they cover different trials? Why doesn't somebody go to Mississippi and cover the poor Jackson State football player who was murdered by his roommate over a donuts? They argued over donuts, and he was playing for Coach Prime, and he was murdered the day before Coach Prime announced that he was going to Colorado. It's annoying, right? So tell me this, why can't they cover different trials? Okay, so right now, Law and Crime Trials is covering live streaming the Texas versus Tanner Horner. That's the Athena Strand trial that I just told you about. They just finished up the Hawaii trial of Gerhard Koenig. The serial killer trial is over. The verdict came in. So they're done with that. Tomorrow they're doing the sentencing of Florida versus Shelby Neely. I don't even know what that is. And then Court TV. I mean, do they need programming advice from me? Court TV is also live streaming the same sentencing, Florida versus Shelby Neely, tomorrow. They're also filming the live streaming the murder of Athena Strand trial, and they just finished the Honolulu case and the serial. Why can't they do different trials on each channel? Wouldn't that make so much more sense? There are so many interesting trials. Hello. Oh, wait. Hello. There are so many interesting trials going on in these United States of America. So many more nuanced trials that you could be covering. Court TV and Law and Crime that people want to watch, where, I don't know, maybe, for example, somebody might actually be being wrongfully persecuted. Do you think that could ever be a possibility? Maybe you could find some as such trials like that we might be interested in. I don't know. It's just a thought. But no, I guess I didn't. I never transferred Cardi B over to this computer. Wait, unless it's in here somewhere. Wait, hold on. I think I did. It takes me off the screen though. Here we go.
Hello.
Hello. Hello, I'm here.
I mean, right. They would only get twice the views. It only makes sense. Dan Abrams, call me. I have some really great ideas for your channels. They decided they're going to pivot their platform to streaming, and yet they're streaming all the same stuff on both exact channels, and took away, I think, Vinnie Politan's show. And Matt Johnson is gone. I'm going to try and get him to come on the show. He said he would. So their viewers all think defendants are guilty, says LC Dunley. I don't know. They need to change their business model. Be in trouble says they're mainstream media. I don't know. Are they, though? So many people turned away from Court TV after the way that they handled the Karen Reed case, aside from Vinnie Politan, the way that Julie Grant went after Karen Reed, and the way she went after Sarah Grace Patrick. It's a problem. Nothing further, says Melanie Rashawn Jones. I don't know. I'll have to look into that. Where is it? Is it an actual trial? I need a trial. I need a trial that's coming up in the next couple of days or next week to get us back to gavel coverage. Yes, I did hear this, Diane. Unions call for North Andover police chief's removal. Yes, Charlie Gray. They have asked that Charlie Gray, there's a vote of no confidence in Charlie Gray. And apparently they're asking for him to be removed. Are you shocked? Are you shocked? I'm not. Yes, on Gavel. Yeah, there's one coming up at the end of the month. The American Idol pastor, the crying, sniveling pastor. That's supposed to be starting at the end of April. And so, as always, if you have any ideas for an actual trial that's coming up, Spencer, I don't know if it's going to be televised, but it's not coming up until like June or July. We're only in April right now, friends. We're only in April. And let's see, Monday, Jesse Butler is supposed to have a hearing. Remember Jesse Butler from Oklahoma? There's supposed to be an evidentiary hearing. I'm going to check on that to see if it's going to be televised. And that should be televised. Hello, Hello, Law and Crime, Court TV, Jesse Butler in Oklahoma, the rapist who got a slap on the wrist despite raping 2 young girls who were in high school with him. Yeah, he was supposed to get 70 years or something. And then the judge was like, oh, no, just go to counseling. Yeah, that guy. Aiden Carney also has a hearing at 2 p.m. That's not going to be televised. Tuesday, there is a Fitzsimmons evidentiary hearing in Essex Probate Court. I don't think that's going to be televised, but if it is, we'll cover it. And then at 1:30, there is a pretrial conference on Sean Higgins, who he's charged with the murder or the reckless killing of Johnny Hockey Gaudreau and his brother Matt Gaudreau, who were in New Jersey for their sister's wedding when they were tragically killed riding bicycles when Sean Higgins, who claims he wasn't drunk, went around some cars to the right and killed them both. That is Tuesday in the afternoon. We'll cover that. And the Caleb Flynn trial is supposed to start on April 28th. Literally, that crime was what? Like a couple of months ago? Probate is not televised or streamed in Massachusetts, but one of them was, Suze, because I said the same thing, and then somebody pointed it out to me that one of those hearings actually was televised. I don't remember which one. It was one of the early ones. One of the Fitzsimmons one. All right. Yeah, that case in the Bahamas. I heard about that case in the Bahamas. The thing is, if you know anything about Bahamian law, I'll tell you what, Karen. Lindsay Shiver, hers is a Bahamas case too. And I did one show on Lindsay Shiver. It was like 3 years ago. And the Bahamian prison, holy crap. I had a whole video on the Bahamian prison. It is like the worst conditions you've ever seen in your life. And it can take something like 10 years to get to trial in the Bahamas. So I don't know. People were telling me Lindsay Shiver's trial's coming up. And I'm like, yeah, no, it hasn't been long enough. The backlog in the Bahamas is insane. Absolutely insane. The new trial starts May 8th. Rashawn Jones, football player in Miami in 2006. It just went in March. Mistrial, new trial starts May 8th. Okay, is it interesting? Does it have some nuance to it? Thank you, nothing further. I will look into it. Stinky Face says a former Massachusetts judge, yes, Judge Erskine, I like her, Carol Erskine, was on Defense Diaries, and she said it looks like they are impounding all filings for the Fitzsimmons case. She said she would not be surprised if they close the court. Yeah, she's got a lot of really interesting takes. She fought really hard, and I think wrote a book about Harmony Montgomery, that horrific case out of New Hampshire. And she's got a lot of, and she's been a judge in family court. I don't know if it was in Massachusetts or New Hampshire, but she's got some great opinions. Go on over to Defense Diaries and check that show out. I did listen to some of it. Kiwi Crypt Keeper says I'm late, but have we covered Chef Gray being asked to remove? Actually, it's Chief Gray. And in North Andover, he's been asked to, they voted no confidence in him. I just literally talked about it. I didn't show any video on it. This is my second show of the day. We're now getting into 3 hours, and I do owe you a reading of the 38 pages of Justin Alayan's filing that he filed against Kelsey Fitzsimmons to try and get custody of the child. And so we'll cover that at the same time. But yes, that is true. Thank you for your 5. And Fire Pilot's wife gifted 20 memberships. What? Congratulations to the 20 new cupcakes. Welcome. And check out all of the amazing emojis for members. Welcome, welcome, welcome to all 20 new members. Thank you. That's very generous of you. Thank you so much. And Music to My Soul says, do we have a specific trial date for Aaron Spencer? I believe they expected sometime in May. Have there been any more filings in that case? Well, I can't look right now on the docket, but I do have it in my calendar, and I'll tell you the date that I have. I have June 22nd. That is the last thing I have in my calendar. I do not think it will be moved up closer in time than June 22nd. I imagine that is when they say trial starts, they mean like jury selection. Or initially, they only expected that trial to be 5 days long. And so because a new judge has been assigned, it could change everything. They could allow cameras in the courtroom. Hello, Court TV, maybe get in there. Make a motion in front of the new judge. The new judge might allow it. He wants things to be a little bit more, public and on the up and up. And so that's all I know for now. All right, my friends, I love you all so very much. I'm sure I will see you tomorrow with something else. What it is, I do not know yet. What time? I don't know yet. But that's why you want to have all your notifications set, or just check back later. But make sure your notifications are set to all. Make sure they are enabled on your phone. And thank your moderators, tip your servers. I'll be here all week. Well, it's already Thursday. Well, I'll be here over the weekend too. So don't worry. We have so much to catch up on because I was in Hawaii and Boulder, and I love you so much. I missed you terribly. But I'm going to see you real soon. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet. I know you guys can do it. I know you can. Peace out, my friends. Thanks, mods. I love you so much. Good night.